May I have my lordship's kind leave to mention with regard to item number 176 of today's list. There is extreme urgency in the matter because the date of possession, of delivery of possession is fixed on 1st of September. So I'm beseeching your lordship, if my lord takes up this matter today at 2 p.m. or as my lord directs. Item number 176 of today's list.
Has anybody entered appearance?
No, my lord, there is no
against this
caveat.
party?
It's the first time the matter is happening. I have mentioned many a times, my lord. My lord will find those slips in the file itself. But unfortunately,
before
that
this
was not.
bench, before this bench.
No, before, time to time different.
First, you can give the mentioning slip. Have you given the mentioning slip?
Yes. 176.
The matter will appear on Monday.
Monday. Grateful, my lord.
ওটা ওই মানডে দেখুন তো মানডে at the top কিছু আছে? Have you annexed the part head আছে part head কি CO দুটো CO তাহলে ওই
তিনটে আছে দুটো একটা দুটো তিনটে SA9 আর CO2
তাহলে part head এর পরেই রাখবেন ঠিক আছে have you annexed the last orders copy of the cert last order?
Last order till this, at the time this application was filed, I have annexed that order.
Yes.
After that, my lord, I have not filed. May I file a supplementary affidavit, lordship?
No, along with the mentioning slip, have you filed whether it is fixed on 1st of September or not?
Because those orders of miss case is not appearing in the CIS.
How can it be?
It's only the dates are given. It's not in the CIS, my lord. I'll bring that dates on the date. I'm extremely grateful.
May I have your lordship leave to mention item number 88. The matter appeared on 14th. Your lordship fixed it on 19th. But I have accordingly served the notice. Matter appeared as item number 88. Tomorrow is the matter fixed in the lower court, in the court below, for final hearing.
Final hearing in respect of?
In respect of the application order which is under challenge here.
What is the crux of the application?
Order 7 rule 11, they have filed an application for basic performance after 30 years. Lord, I have challenged that order, Lord, court below has not passed any order against that, I have filed an revision application. That revision application, time to time appeared, lastly, it was heard by Justice Omnaran Rai, then
1 minute, Learned Counsel. The civil revision has been admitted?
Yes, not admitted, admission.
As such, so it has been directed to be served upon the
Yes, I have
party?
served, I have served.
Mention it
I have
tomorrow.
Served,
mention before the trial court tomorrow, the same thing.
It has mentioned, order was that, when matter was heard, earlier by Justice Om Naran Rai, it is understood that they will take time. They will not taking any time, when the matter was heard. Tomorrow is the matter fixed, in spite of observation made before by this, by the other bench. But if your lordship kindly take it up at 4 p.m. or 3:30, I'll serve the notice. But only, if it is not time permitted.
Is anybody appearing?
Yes, yes.
Appearing.
Yes. I have served notice other side, earlier, as per your lordship's direction on 14th itself.
Intimate the learned counsel representing that your adversary that the matter will be taken up at 2 p.m.
Lordship.
My lord, may I permit to mention the matter contested application hearing?
For inclusion?
Yes, my lord. I have served notice to the other side also, my lord. Grateful.
Lord, mention a civil revision application for inclusion.
যেটা এখান থেকে বলছি সেটা নোট রাখবেন, বুঝেছেন? কোন একটা 2 PM এর রাখুন।
Item number 1,
Want to there where that he is not
Item number 1, 2, 3 তিনটে করে দিন। 1, 2, 3.
not
That
we-
matrimonial arising out of
rising out
matrimonial.
of matrimonial suit, not interlocutory orders. Now, Lord, the decree has been passed.
Hmm.
These applications have become infractions.
Mr. As regards to those applications in which your client is the petitioner,
Yes.
those can be,
But the other can be also dismissed because these arise out of the same order.
same order. um, It should be, but in the absence of the other side,
But the
I think,
other side
I think in respect of these two matters, the order is being passed. In respect of the third one, wherein
No, the first one is my matter.
first one,
I am the petitioner.
yes,
I challenge
first and
the first one.
only the first one. So
Second,
second and third is of theirs. That is the wife, Ratna Chatterjee.
yes.
So would you be kind enough to intimate, as regards to the first one, the order is being passed today.
But I think, Lord, the three matters should be dealt with in one order
Achha.
because, Lord, it's arising out of the same order.
So-
Lord, if
so-
your lordship,
So in that circumstance, let the matter can be taken up on Monday.
Very good.
And in the meantime,
I'll,
um,
my lord wants,
be
Lord, a
inti-
service of a notice
yes, upon the,
because nothing survives. They
No.
are also not interested.
but they will say that in the absence of ours, how can it be?
Leave it.
It will give something.
Leave it.
uh,
Kindly, Lord, place it on Monday, then.
Monday will be,
Yeah, absolutely.
Yeah.
But I believe your lordship's list is heavy on Monday. Instead of Monday, we can go to Tuesday.
Tuesday.
Also, in case the
একটু দেখুন তো টিউসডেতে কোনো টপিক কিছু আছে কিনা টিউসডে। নেই তো টপিক। So Mr. Coy, it will be appearing on Tuesday.
Tuesday at the top. Lord.
Yes,
Much.
obviously. Learned Senior Counsel representing the petitioner husband, as had been earlier submitted, also submits that in view of the matrimonial suit being number 103 of 2017 being dismissed, and the counterclaim of the wife for restitution of conjugal rights also been dismissed. Conjugal right also been dismissed. As such, the revisional application being number CO 78 of 2019. আচ্ছা, তিনটে থেকে আলাদা আলাদা অর্ডার হয়েছে, তাহলে শুধু শুধু না 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 সেটা ঠিক আছে, শুধু এই নাম্বার গুলো চেঞ্জ হবে, ঠিক আছে, সিও নাম্বার গুলো চেঞ্জ হবে, হ্যাজ বিকাম ইনফ্রাকচুয়াস। এইটাতে সিও 78 2019, অন্যটাতে যেটা নাম্বার সেটা
There are two numbers,
become-
3636 and 3637 of 2018.
has become infractuous. Full stop. As such, learned senior counsel submits that the instant revisional application is not proceeded, be not proceeded. Full stop.
Has become infractuous.
Yes, that has been mentioned. Full stop. The wife, that is the opposite party herein, is not being represented. আর ওই দুটোতে the wife petitioner herein উল্টোটা হবে, is not being represented. As such, the present revisional application is being fixed on টিউসডে হচ্ছে 25th of August at the top, full stop. Follow. The learned advocate representing the petitioner husband is requested to intimate the learned counsel representing the opposite party as regards to the next date.
But kindly also observe that in case, my lord, the parties go unrepresented on the next day, the matter will be dismissed.
If in spite of receiving information, the wife being not represented, then in that case, necessary order shall be passed
In their absence. Much.
in their absence. In their absence করে দিন।
Much.
ডাকুন
Item number 2, 4.
For the respondent number 1.
My lord, this is an application, the CAN 4, my lord. It's an application for substitution, my lord. The sole appellant has expired, my lord.
CAN 4 of 2025.
Yes, your lordship. It's an application for substitution, my lord.
And CAN 3, my lord, respondent number 2 has also expired. He is brother of the appellant and co-owner of the tenanted suit property. So our prayer is that respondent number 2 should also be substituted. Let appellant be substituted, but respondent number 2 also should be substituted.
In regard to that, any application has
My lord,
been
the
filed?
application is CAN number 3, my lord. CAN 3, it's for appropriate orders, my lord. They had not appeared before the trial court, my lord. Kindly see, my lord, the CAN 3 is an application for appropriate orders, my lord.
এই যে এটা খুলে যাচ্ছে, এটা এর সাথে থাকবে। এই ক্যানটা হিয়ারিং হবে, এই ক্যানটা উপরে দিয়ে দিতে হবে। যে ক্যান অ্যাপ্লিকেশনটা হিয়ারিং, দাঁড়ান দেখি। দাঁড়ান নম্বর ক্যান আসতে ক্যান 340 ওখানে অর্ডার বুকে তো, হ্যাঁ আরে শুনুন, অর্ডার বুকে অর্ডার গুলো থাকবে, অর্ডার বুকে এগুলো থাকবে না। এটা দিন। আচ্ছা ওইটা ক্যান বা সবকিছু এইখানে থাকবে, বুঝলেন? ওখানে শুধু অর্ডার। হ্যাঁ এটা একবার বলবো না, এটা নোট করে রাখবেন, ঠিক আছে? ক্যান 3টা দিন, ক্যান 3টা আর ক্যান 3 নেই। হ্যাঁ ক্যান 3 দেওয়া সত্য। এটা কি আছে? এটা এই তো এটা ক্যান 3, এই তো ক্যান 3। এটাও বার করে দিন, এটা দিন। Yes, first of all, CAN 3.
CAN 3, my lord, it's for the exemption, my lord. But before that, my lord, the CAN 4 has to be allowed, my lord. The CAN
Substitution
of the sole appellant.
Dilip Banerjee.
Yes, your lordship.
Yes, Lord Counsel.
Regarding substitution of sole appellant, I have no objection.
No objection.
That
Clean. can 4 of 2025. Name of the
Malord, the
legal heirs,
name of the legal
page
heirs,
2,
Malord.
paragraph 2.
Yes, your lordship, it's a paragraph.
Joya Banerjee wife, Shubhankar, name. এটা হচ্ছে can 4 of 2025. ঠিক আছে? The said application has been filed seeking substitution of the sole appellant, namely Dilip Banerjee, who has expired. Full stop. To the said application, the legal heirs of the said appellant have being the wife, namely Joya Banerjee, and the sons, namely the sons, namely Shubhankar Banerjee, Subhankar. The spelling is correct.
Yes, your lordship, it's the spelling is correct.
Subhankar, Shubhankar Banerjee, and Dipankar, Dipankar, Dipankar Banerjee, intend to be substituted. It is mentioned, sui juris.
Yes, your lordship, it's mentioned in paragraph number 5, Malord.
The learned counsel representing the respondent number
One minor.
Satish Das.
That is tenant.
The learned counsel representing the respondent number 1, namely Satish Das, does not object to the same. Full stop. As paragraph, as the application is for substitution of the legal heirs of the sole appellant plaintiff who has expired, so the said application is allowed. Full stop. Department. Okay, the names of the legal heirs of the names of the legal heirs being wife and the 2 sons be substituted in place of the original appellant. Full stop. Department to do the needful. ডিপার্টমেন্টটা বোল্ড করে দেবেন, ঠিক আছে, তাহলে চোখে পড়বে, পাঠিয়ে দেবেন। হ্যাঁ, can afford is substituted.
I'll be requesting your lordship, let the proposed appellants be taken on record, my lord, and your lordship may keep this can 3 application.
You have filed the wakalatnama on behalf of them while furnishing this
Yes,
application.
Yes, your lordship, the names has to be corrected by
That will be done by the department.
That will be taken care of, my lord. The can 3 application, my lord, we had exchanged our affidavits to it. My lord, my learned senior friend has also filed their opposition, and I have also filed my reply to that effect, my lord.
The Deepak Kumar Banerjee has expired,
Yes, my lord. Deepak Kumar Banerjee.
and Shapon Kumar Banerjee is
My lord,
respondent number 3, Shapon Kumar Banerjee. So there are several.
Yes.
Several is known,
your lordship,
not
will-
only Shapon Kumar, but several.
Several others are
your
there.
lordship,
1 minute, 1 minute.
yes, you, my lord. Yes, my lord.
3 Shapon Kumar Banerjee.
Yes, my lord.
Thereafter,
They are all.
okay, he has also expired. His name has not been expunged, but
My lord,
3A, 3B,
yes,
3C.
your lordship, they're on
Yes,
record, my lord.
Meena Banerjee, they are on
They're
record.
already on record.
They are already on.
So why have you mentioned the name of Shapon Kumar Banerjee?
My lord, it's from the trial code itself, my lord. That is the reason.
Dev Kumar Banerjee, Latika Banerjee. So yes. So we can take up the
Yes, my lord. Our main
application.
point is that respondent number 2 is the co-owner of this suit property. He is the brother of the erstwhile
Appellant.
late appellant.
Mm.
And he is a co-owner, and he had already issued a letter of atonement in our favor. In my affidavit in opposition, I have annexed a copy of that letter of atonement. There he had issued a letter saying that I am the executor of my late father's will, and you should pay the rent in my name. And following that, we had actually
You had
deposited
been paying and you have been paying
before- Yes,
the
yes,
rent
my
to
lord.
Deepak Kumar Banerjee.
Deepak Kumar Banerjee before the rent controller in name of Deepak Kumar Banerjee. Say against this background, if his name is expunged, then it will cause prejudice to my client, my lord. So his names legally should also be substituted.
My lord, I don't understand why my learned friend is harping on that. He will be prejudiced, my lord. My lord, the tenant is stopping from the questioning.
Learned
properties
counsel,
of the
learned
landlord.
counsel.
Yes, my lord.
You are the brother.
Yes, my lord, I am the brother.
What is harm in substituting this Deepak Kumar Banerjee
Lord, he
once he has
has-
expired?
My lord, I will requesting your lordship, I will come up with the propositions of law, my lord, why it's not necessary to substitute him, my lord. Kindly keeps this matter on Monday, my lord. I'll come and I'll argue this point on this point, my lord. Kindly.
After hearing the submission of the learned counsel of your on the adversary, this court is of the prima facie view.
Very well, my lord.
He is to be substituted. Can 4, can 3. ঠিক আছে দরকার নেই পরের লাইনে লিখে দিন ওটার পর let the application being can 3 of 2024 আচ্ছা affidavits have been
Yes, my
exchanged,
lord, it has been exchanged.
have been filed
Yes, my lord. And
today.
no,
my lord,
earlier,
earlier occasion, it
earlier
was-
আচ্ছা শুনুন এর ওই আছে affidavit in opposition আছে affidavit in reply ও আছে একটু দেখুন তো can 3 এর মধ্যে দেখুন কি করবেন বলুন তো can 3 তো অ্যাপ্লিকেশনটা এর তলায় রাখবেন affidavit in opposition, তার তলায় affidavit in reply, একদম তিনটে একসাথে বাঞ্চ করে দেবেন, দেখে নিন আছে কিনা শুধু। ঠিক আছে শুনুন, on consent of both the sides, আচ্ছা ধীমান বাবু এই আছে affidavit in opposition, affidavit in reply দুটো আছে তো আগে ওপর দিন দেখে। আচ্ছা এটা ডিপার্টমেন্ট থেকে সাবস্টিটিউট হয়ে এখানে এসে পৌঁছবে কবে? আগামীকাল এসে যাবে তো? তাহলে লেট দ্য ম্যাটার বি ফিক্সড অন দেখুন 25th দেখুন তো টিউসডে, 24th রাখুন 24th।
Yes, ma'am. 24th.
24th
Monday, my lord.
মানডে।
Monday, yes. Yes, ma'am.
affidavit in opposition, affidavit in reply, এই একদম এরকম ভাবে থাকবে। তাই নিন আমি সাজিয়ে দিয়েছি, আজকে ডিপার্টমেন্টে পাঠিয়ে দেবেন, নামিয়ে দেবেন, মানে সার্ভার হয়ে গেলে আগে দিয়ে দেবেন, বুঝলেন? এটা তাহলে সই করে দিয়ে দেবেন। হ্যাঁ হ্যাঁ নেক্সট
Item number 5,
my lord.
24th of August, fixed on 24th।
Oh, that's okay. Sorry, sir. Sorry, sir. Sorry.
কোনটা? হ্যাঁ ওই পেপার বুক 2 আর 3 এসেছে তো? না না অর্ডার হয়েছিল, পেপার বুক 2 আর 3
Message
আনতে
করে
বলা
বলো,
হয়েছে।
যা বলার।
না 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 অর্ডার পেপার বুক 2 and 3 আনতে বলা হয়েছিল, শুধু 1 ছিল, আমি সই করেছি অর্ডারে। হ্যাঁ অর্ডার আছে,
হ্যাঁ,
অর্ডার বার
করে দিস।
অর্ডার আছে, অর্ডারটা বার করুন। মিস্টার মিত্র
Yes.
আছে।
পেপার বুক সার্ভিস করছি।
হ্যাঁ একদম খেয়াল রাখতে হবে অর্ডার শিট, আর অর্ডার শিট ওর ভিতরে থাকবে না, ওকে সব ঢুকিয়ে দিন।
এটা বলে দাও।
Yes, Mr. Mitra.
Suit decreed, my lord, suit for eviction.
Shoot for eviction.
Yes.
You are the
I am the plaintiff.
plaintiff landlord.
Yes. Now, my lord, thereafter, my lord, an application, my lord, as usual, my lord, an application under order 21, my lord, rule 90.
297.
Yes. That was, my lord, rejected
Hmm.
by the executing court on contest.
On contest.
Then, my lord, an appeal therefrom, the appellate court had reversed the order. My lord, we are before your lordship from that order. My lord, only thing, my lord, if your lordship is once, please to come to page
The paper
391, the last volume,
paper book.
volume 3.
Volume 3 টা দিন পেপার বুক। এই তো এই তো এই তো এই তো। ভলিউম 3 টা দিন। আস্তে 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 নোট করে করে ভলিউম 3 টা 1 2 3
আমি রেসপন্ডেন্ট দিচ্ছি।
পেজ নাম্বার
391, my lord, towards the end of the paper.
কোনটা দিলেন? এটা তো ভলিউম 1 দিলেন, ভলিউম 3 দিন দিন। 394
391.
391 yes 391
My lord, kindly omit, my lord, the can portion. Kindly come to the next portion starting from paragraph 3. The appeal is now taken up for hearing under order 41 rule 11. Upon hearing learned counsel appearing for the appellants, we are of the opinion that the present second miscellaneous appeal should be heard on the following substantial questions of law: whether the learned first appellate court committed a substantial error in law in reopening the decree passed in the suit while adjudicating an application under order 21 rule 97 to 101, which is supposed to be premised on an independent right from that of the parties to the main suit. Whether the learned appellate judge committed a patent perversity in observing that the decree was inexecutable in view of non-implement of the applicants in the application under order 21 rule 97 to 101 in the suit, which is beyond the case of either party. Whether the learned first appellate judge committed a patent error of law in misinterpreting the effect of section 2G of the West Bengal Premises Tenancy Act 97 insofar as the moratorium period of 5 years has long elapsed after the demise of late so-and-so, through whom the present respondents applicants in the executing court claim to have derived tenancy, rendering them rank trespassers even assuming that their predecessor in interest was a tenant in his own right. The applicant shall put in the requisites, etc. These were the issues, or well, these were the main questions.
so Crux was 2G, section 2G.
Yes. And my lord, whether my lord, the court, my lord, could have gone into, my lord, the all, my lord, what we have learned, my lord, that the executing court, which is hearing, my lord, cannot go behind the decree. The executing court had gone behind the decree to say that, my lord, this decree is, first question, inexecutable.
You are representing the
I'm the respondents, my lord. I'm led by Mr. Anirban Kaur, my lord. আপনি করুন স্যার, দাদা তো আজকে নেই। My lord, Mr. Kaur is not here, my lord. He is out of station for some matters, my lord. My lord, let Mr. Mitro start the argument, my lord. I'll take notes on the next occasion, my lord.
My lord, I don't mind, my lord, but the only difficulty is, my lord, I personally feel, my lord, that this appeal should be, my lord, heard
at a stretch.
yes, not in piecemeal, my lord. I cannot remember, my lord, what I have said. It becomes difficult.
My lord,
It will not take long, my lord. If your lordship is pleased to fix any day, my lord, we can.
next Thursday, my lord.
When can it be fixed?
My lord,
Oh. Week thereafter, my lord. Next Thursday is, my lord. Friday is possibly closed, so, my lord, an uncertain day.
Wednesday, Wednesday probably is
Wednesday.
holiday. Probably Wednesday.
Wednesday is the holiday, my lord. Wednesday is the holiday.
Probably.
My lord, keep the week thereafter, my lord. To be
Which
on
date?
the safer side.
Which date? Which date? Whichever date suits both of you. পরের বৃহস্পতিবার যদি হয়
হুম।
সেটা হচ্ছে আপনার 27 তারিখ আর
হুম।
আগের দিন ছুটি, কিন্তু পরের দিন ঠিক আছে, তারপরের বৃহস্পতিবার আবার 3 তারিখ 4 তারিখ ছুটি। তাহলে
না,
পরের
27 তারিখ,
27 তারিখ থাক, তাহলে 27 তারিখ
27
থার্সডে।
That's- May I file the affidavit?
প্রথমে নিয়ে নিন অ্যাফিডেভিট অফ সার্ভিস। দেখে নিন, he kept to the record and put so, the learned advocate representing ওনার নামটা নিন, representing the respondents submits that learned senior counsel who will be representing the respondents herein is out of station. Full stop. Paragraph as such, on consent of both sides, let the matter appear on 27th of August,
That's-
27/8/2026.
I'm-
আচ্ছা, 27th দেখুন তো টপে কিছু আছে, কিছু টপ পার্ট হেড আছে কটা? একটা, আফটার দ্য পার্ট হেড ম্যাটার।
Very
Grateful.
inspection. My lord, if required, can we take inspection of the lower?
Yes, yes,
grades?
of course. It will be better to have the inspection.
Yes, yes. I'm
ছিল না নাকি? Next.
Item number 6.
Tafun.
Item number 6.
Item number 6, I am appealing on behalf of the petitioner, my lord. This is a expeditious
Appearing
hearing
for
of
Appearing for the first time. Expeditious hearing.
expeditious hearing, my lord. This is a case of suit for This is, my lord, a suit for recovery of khas possession and injunction filed in the year 2014 to 2024, my lord.
Filed in the year 2024.
24, my lord. Title suit number 383 of 2024, my lord. My lord, kindly come to the ordering portion, my lord. I have challenged
What stage it is?
in the order dated 6th July 2025. Till date, my lord, no WS has been filed by the defendant, my lord.
You are referring to which order? Order dated
Order dated 16th July 2025.
16 July 2025.
On that date, my lord, a date was fixed for 22/4/2026, my lord. But I have furnishing, my lord, one copy of the information slip, my lord, one photostat copy of the information slip, my lord. From that date, my lord, here's already WS and W has been filed on 12 May 2024. This is, my lord, the original copy.
এটা থাকবে রেকর্ডে।
Original copy. 12th May 2026 and, my lord, 25th
One minute.
11
One
2020.
minute.
Paper password 92. What? Only two-matter password. Only two-matter password. Engaged in code number 21. Only, my lord, two-matter password.
Yes, in respect to the second, what is mentioned here? No defendants.
No defendant.
No defendants have
Not filed the written statement and written objection till
on 22nd April 2026.
26, but on 12th May 2026. Matlab on the 12th May and, my lord, next, my lord,
So,
25th 11/2026 for acceptance of the W&W.
Yes. What are you seeking?
I am for expeditious hearing, my lord. Actually, my lord, I have filed the matter before passing of that order, my lord, the 12 May. It was filed before passing of that order, my lord.
Learned Counsel, title suit of 2024. Written statement has been filed. Now it will proceed automatically.
I only prayed for disposal of the order 30 rule on to application. Nothing more, nothing less. Yes, disturbing our peaceful position, my lord. That is the ground.
Mention the prayer portion.
As a expeditious hearing, then nothing more. So what else to wait out?
What you have submitted just now is not mentioned in the prayer portion.
That is the statutory prayer, my lord. Copy paste, sir.
Learned Counsel, being a title suit of 2024,
I know, my lord.
Nil. If it had been much earlier, then order ought to have
I
been.
know, my lord. Title suit minimum 5 to 6 years is period.
The Learned Counsel representing the petitioners submits that furnishes and a copy of the information slip. Petitioners submit a copy of the information slip, and from the said information slip, it transpires that written statement and written objection has been filed on behalf of the defendants on 12th of May 2026, and it is fixed on 12th of November 2026 for acceptance of the written statement. Full stop. On perusal of the record, it transpires that the title suit is of the year 2024. Considering the status and the year of filing of the suit, this court is not inclined to pass any order for expeditious hearing. As such, the application is rejected.
At least, my lord, order 30 rule on to application should be hard.
In your prayer, is there anything? That's why I was. That's why I was.
I have prayed for, my lord.
That's why I was requesting.
As well as all connecting applications.
If that had been there specifically,
I have prayed, my lord. Title suit as well as all connecting applications, my lord. At least, my lord, that can be I can pray for.
লাস্ট দুটো সেন্টেন্স কি রয়েছে দেখি, লাস্ট দুটো সেন্টেন্স ইয়ার 2024, হ্যাঁ তারপর আচ্ছা ফুল স্টপ ওটা counsel, once it has been passed, let it be. Once it has been passed, let it be.
Item number 7.
The plaintiff is the petitioner before my lord.
ওইটা রেখে দিয়েছেন তো, ওই যে কপি অফ দ্য ইনফরমেশন স্লিপ? Yes.
A plaintiff is the petitioner before my lord.
Hmm.
My lord,
Suit for
declaration of the pathway along with confirmation of possession. My lord, kindly see the copy of the plaint first.
Plaint is in page number.
Page number, my lord.
Yes.
Page number 8. এই পথভূমি থাকা সাব্যস্তে দখল কায়েম তদ্ভাবে দখল পত্তন ম্যান্ডেটরি ও স্থায়ী নিষেধাজ্ঞা বাবদ প্রার্থনা সাচ and such. Kindly see my lord page 14.
Lord Council, prayer portion.
Prayer portion page 13. নিম্ন ক তফসিল বর্ণিত ভূমির বাদীর বাসগৃহ হইতে উত্তরের সরকারি রাস্তায় যাতায়াত করার জন্য একমাত্র পথভূমি বিধায় উক্ত পথভূমিতে বাদী ও বাদিনীর পরিবার বর্গের যাতায়াত করিবার কার্যে মূল বিবাদীগণের বিঘ্ন উৎপাদন করিবার কোনো অধিকার না থাকা মর্মে প্রচার করিতে আজ্ঞা হয়। নিম্ন তফসিল
Have you annexed any rough sketch map with the plaint?
not draft sketch, that report filed by the commissioner.
Acha.
May I show that?
Order 39 Rule 7 has been
2 times have been allowed.
twice.
My lord, to show the condition of that pathway, your lordship will kindly see
One minute,
the
Lord Council, no, along with the plaint that is in page 15,
yes, page 15.
that is the,
This is the pathway. Your lordship will see in the,
which
from
one is
the
the pathway?
middle portion, mark A, B. Have your lordship got it
It
with blank
It is
ink?
north, south or east, west? Which
In
one?
north, south,
North, south.
my lord. North, south A, this is A,
And
and this is A1.
A1 is?
A1 is just below. Your
No,
lordship will, you can see.
Found it, but what is A1?
A1 is that pathway that kindly see A, have your lordship got it?
A
And
is,
your lordship will kindly see A1.
A is north, south.
সরকারি রাস্তা মৌজা বাসুদেবপুর. Yes, my lord, kindly see A.
A is north, south, and A1
Is that strip of land?
east, west.
This is the pathway.
This one is A1 is the pathway.
A and A1 are the
Both.
scheduled plot of land
Acha,
in the suit.
acha.
A1 is part of A. Now your lordship will kindly see the commissioner report. Kindly see page
You are
23.
possessing?
I am preparing declaration of that pathway. I am possessing that.
Where is your house situated?
My house is situated, my lord, in plot number 642.
642.
Yes.
Yes.
Now, my lord,
So, you first avail A1, thereafter you
A1.
avail A and reach the Chorkari Rasta.
my lord, this is the pathway where I will
Now let us come to the
commissioner report.
commissioner report.
My lord, two commissioner report. Kindly see page 23.
পাহাড়টা তো বন্ধ করে দেবেন তো।
Kindly see page 23.
Page 23.
And 640 is the pukur, that is pond,
Yes,
from the commissioner report.
1 minute.
Kindly see page 23. 640 is the pond.
640. Acha,
Is the pond.
640
That
is
is
the
non-suit plot.
Acha.
My lord, kindly see this pathway. নারকেল গাছের দ্বারা গোড়াটা অবস্ট্রাকশন, এই অংশটা পুরোটাই পুকুরে ধসে গেছে। 3টে নারকেল গাছ যে কোনো সময় পুকুরে পড়ে যেতে পারে। এই অংশটির মাঝে গর্ত, পুকুরে ধসে যাওয়ার উপক্রম। Have you lordship got it?
Yes, yes, yes.
This is the first commissioner report. Next, your lordship will kindly see another commissioner report, that is next page. Same report. এই অংশটিতে মাঝে মাঝে
Page
24, page 24, page 24.
Page 23 is dated 20th of November.
Yes,
20th of November, year
2021,
2021.
my lord.
Acha.
Next matter is also the same report, my lord. This is a, sorry, it has not wrongly annexed. Same copy. Now, another report, kindly see, that is the commissioner report in 2024. Your lordship will get it. I am going to the relevant portion. Kindly come to page 31. This is in the year 2021, and this is in the year 2024. Page 31.
Yes, page 31.
The pathway, have you lordship got it? The pathway has been shown, A and B strip, A1. Now what is,
So the pathway is surrounding the pond,
and the pond,
and there are coconut trees which, as per the
now
first
the
first
pathway has been
inspection.
closed because of this.
Acha,
Now
yes,
kindly see,
place the report.
এই যে A1 স্ট্রিপের কিছু জায়গা, পেজ 31, this is 24. A1 স্ট্রিপের কিছু জায়গায় অবস্ট্রাকশন আছে, রাস্তার বেশ কিছু অংশ ধসে গেছে 640 দাগের পুকুরে। That means ধসে গেছে in plot number 640, which is a pond. H2 তিনতলা বাড়ি, মানে H3 একতলা বাড়ি।
Has this local inspection commission took place ex parte or
After serving notice.
After
That
serving-
notice has been given,
in presence of both sides?
my lord.
Can you show from the report?
My lord, kindly see page 25.
No. That one is that one was in respect of the first one. In respect of the second
Second one, kindly see page 21,
page
the 25.
25.
This is the notice of the commissioner.
1 minute.
And kindly come
One
to
minute,
page,
one minute, Lord, sir.
page 25. This is the notice, page 26, that the report of the commissioner notice has been served. আমি হুজুর আদালতের নির্দেশে এবং উক্ত মোতাবেক মকদ্দমে অ্যাডভোকেট কমিশনার নিযুক্ত হইয়াছি। আমি দুর্গাচর থানা সার্চ অ্যান্ড সার্চ মৌজায় নালিশি 639 ও 642 দাগের ভূমি সহ পার্শ্ববর্তী ভূমিতে সরেজমিনে 25/1/24 তারিখে বিকাল 3টের সময় উপস্থিত হইয়া কমিশন কার্য করিয়াছিলাম।
Lord
I'm-
Counsel, this one is of 2011-2021.
24,
No,
page 26, you lost it.
page 26.
Six.
Oh, you are referring to 25.
No, page 26.
Yes, 26.
25 is the notice, I am not reading, but page 26. আমি প্রথমে বাদী ও বিবাদীকে ফিল্ড নোট প্রদান করিয়াছিলাম। বাদী উক্ত ফিল্ড নোটিসে টিপ দিয়েছেন এবং বিবাদীগণের উক্ত নালিশি ভূমিতে উপস্থিত ছিলেন, কিন্তু বিবাদীগণরা কেউ ফিল্ড নোটে কোনো স্বাক্ষর করেন নাই এবং উপস্থিত ব্যক্তিগণরা ফিল্ড নোটে স্বাক্ষর করিয়াছেন। That is the report of the commissioner.
Mhm. So
Signed in the
so
court
it
bill.
took place in presence of both the sides.
Both of them. And they have
Yes.
now signed the field note, though they were present.
Yes.
Now, my lord, only one thing, your lordship will kindly see page 37. One mistake has been committed. That is, kindly see page 37,
Committed by whom?
committed by the learned advocate in the trial court. Although, my lord, there are several judgments that wrong mentioning of section is not fatal. Ultimate gist of the-
Representing your client.
Well, kindly
which
see
one?
at the top, দেয়ানি বিধি কার্যালয়ে অর্ডার 39 রুল 4 মতে ইনজাংশন আদেশ মডিফিকেশনের প্রার্থনায় দরখাস্ত তরফে বাদিনী। This is the mistake. It should be for repair of this road. Now kindly see of the body of this application, there is certified
Where
copy.
is the prayer? Where is the prayer of the?
Here, yes, my lord, I am showing. My lord, kindly see next page 38,
38.
para 6 and 7. হুজুর আদালতে have you also got it? হুজুর আদালতে ইনজাংশন আদেশ থাকায় বাদিনী একমাত্র চলাচলের এ স্ট্রিপ ভূমি ও A1 স্ট্রিপ ভূমি রিপেয়ার করা সম্ভব হয় নাই। প্রতি বছর 640 দাগের পুকুরের জল বাড়িয়া এ স্ট্রিপ ভূমি সহ A1 স্ট্রিপ ভূমি ডুবিয়া যাওয়ায় চলাচলের রাস্তা নষ্ট হইয়া পুকুরে ধসিয়ে যাওয়ার উপক্রম হইয়াছে। From the report of the commissioner, বাদিনী নালিশি এ স্ট্রিপ ভূমি সহ A1 স্ট্রিপ ভূমির বর্তমান অবস্থা বিষয়ে সরেজমিনে তদন্ত করিবার জন্য পৃথক লোকাল ইন্সপেকশন দরখাস্ত করিতেছে। নালিশি ভূমি আর অর্থাৎ আর্জির হাত নকশায় এ স্ট্রিপ ভূমির গর্তগুলি রিপেয়ার করত মোরাম ফেলাইয়া চলাচলের রাস্তায় ড্রেনের উপর স্ল্যাব বসিয়া চলাচলের উপযুক্ত সহ A1 স্ট্রিপ কমন পথভূমি রিপেয়ার করা আবশ্যক, অন্যথায় অধীনে বাদিনীর ক্ষতিপূরণ হয়। Ultimately, this is the prayer. But wrongly, the caption is wrong. Well, that is, I am
And
admitting,
defendants are the owners of the pond.
not pond. My client is owner of 642 and 639. They have also share
1 minute,
30. This is shoot plot.
642 and 639.
Yes.
Where is 639?
Defendant is also have got some portion of land in these
One-
two plots.
1
For
minute.
that
1
reason,
minute, 1 minute. Where is 639? Yes, 639. And defendants are the owners of?
defendants are not owners, but they have got some share in this plot. This is a shoot plot.
639,
Yes, 639 and 642.
Hmm.
For that reason,
1 minute.
Rane trial court rejected the same.
In which paragraph of the plaint you have mentioned that they are the co-owners?
In the application itself, I have stated, my lord.
No, in the plaint where you have mentioned.
Oh. My lord, para 13. মূল বিবাদীগণ নালিশি ভূমি তাহার পূর্বাধিকারী হইতে ক্রমশ হস্তান্তর সূত্রে ও ওয়ারিশ সূত্রে প্রাপ্ত হইয়া নালিশি 642 দাগের উপর নির্মিত পোক্তা গৃহাদিতে বসবাস করত সত্ত্ব দখল পরিচালনা করিয়া আসিতেছে। মূল বিবাদীগণের নালিশি 639 দাগের গৃহের লাগাও পূর্বাংশে বাদী ও বিবাদীর পূর্বাধিকারী তথা শশাঙ্ক দণ্ডপট হাফ ডেসিমেল ভূমি বিনিময় মাত্র বাই ডিড অফ এক্সচেঞ্জ বলে প্রাপ্ত হইয়া যাতায়াতের বারাম পথ হিসেবে দখল ব্যবহার করিতে আসিতেছিল। উক্ত বারাম পথের লাগোয়া পূর্বে বেনালিশি 640 দাগের মূল বিবাদীগণের পুকুর থাকায়, দ্যাট ইজ 640 ইজ দ্য পুকুর ইজ অফ দ্য ডিফেন্ডেন্ট। পুকুর 640 দাগের মূল
That I
বিবাদীগণের
was asking. I had asked you whether the pond belongs to the defendant. You said no. Serve.
মানে wrong mentioning is not judgment.
The first step, you serve upon the learned counsel, the opposite party, and come with the citation
Yes,
at the time of
of
hearing.
course.
Nil.
There are five
Yeah.
opposite parties.
The learned counsel representing the petitioner submits that the pathway depicted in the sketch map and shown in the report of the learned advocate commissioners, two reports of the learned advocate commissioners reveal that there were coconut trees on the pathway, and those trees have fallen in the pond.
Yes, the report of the
Fallen,
commissioner says.
in the pond, have fallen in the pond.
Here also you see this pathway,
Uh,
the defendants.
fallen in the pond, and thereby making the pathway unusable. As such, the petitioner has sought for repairing the said pathway as depicted in the sketch maps. Full stop. He further submits that inadvertently, an application was filed on behalf of the petitioner plaintiff. When was the application filed?
On 6th application for repair, that
Yes,
that on
Yes,
rejected
yes,
that
yes.
application. Why not?
let it be on that an application was filed seeking repair of the said pathway.
6th of July 2024.
Application dated করে দিন 6th of July 2024, seeking repair of the said pathway, but inadvertently, it has been mentioned that the application is being made under Order 39, Rule 4 of the Code of Civil Procedure. Full stop. As such, the said application has been rejected on contest by the learned trial court, wide order dated 19/5/2025. He further submits that misquotation of section in the application is not fatal. Full stop. As such, the revision of application is admitted and shall be heard on this point. Full stop. Paragraph. Let copy of the revision of application be served upon the opposite parties. How many are there?
1 to 5
1 to 5. When can you serve and come?
in 2 weeks.
2 weeks. Let the matter appear on and to furnish affidavit of service on the returnable date. Let the matter appear after 2 weeks. তাহলে আজ কত তারিখ? 20 27 27 3 8th of September.
Middle of September
um,
after Bishokam 15th or 16th.
When is Vishwakarma Puja?
17th September.
No, this year probably on 18th September.
Then after. Oh, yeah, absolutely.
After 18th.
No, after in the middle of September.
Then you will have to swim and go to that land, that Pakarasta.
No, I'm not there. Yeah, I'm leaving before my lord. I'm leaving.
No, according to you.
Yes. A copy is to be served.
When to be fixed? According to you.
According to your lordship.
Then it will be fixed on 8th, 9th or 10th September. 10th of September.
Grateful to us.
Next.
Item number 8.
Display হচ্ছে তো ঠিকঠাক ডিসপ্লে না কি বলে সই চেম্বারেই পাঠিয়ে দেবে চেম্বার এখানে হবে না হ্যাঁ ওটা আর্জেন্ট লিখে দেবেন নিন none is representing the petitioner. Let the matter appear on 26th. Also 26th holiday. Let the matter appear on 27th. Next. 27th তারিখ 27th.
Item number 9.
Item number 9, same order. এখানে petitioners.
Item number 10.
In item number 10, I am for the petitions.
And for the respondent.
This was a partition suit
Yes.
between brothers.
Hmm.
2/3, 1/3, because there were 3 brothers. One of the brothers had gifted his 1/3 share to me.
So you are owner of
2/3 share,
co-share of 2/3 and they are of 1/3.
1/3.
There is no dispute as regards to that.
Decree has been passed, final decree.
Acha.
Preliminary decree was made declaring the shares.
Thereafter final decree.
Meanwhile, no, my lord, may I just?
Possession handed over.
No, here what happens is commissioner of partition was appointed. He files a report saying the estate is impartable.
Acha. Why?
So because this is a very small dwelling house, dilapidated condition, cannot be partitioned. That is his report. The report was accepted by the court below, my lord, and a final decree in terms of the report was passed.
No objection was raised on your behalf.
No.
Its property is impartible, that there is no dispute to that.
So
There is no dispute
till
to
that date, till that position, nothing.
Thereafter, my lord, applications have been filed by me as well as by learned friend's client, saying that I want to purchase this property.
Both
My
intend to purchase the
1/3 share he wants to purchase, my 1/3 share, his 1/3 share I want to
want to
purchase.
purchase.
Ultimately, what happened was an order was passed on 5th January 2024.
Is the impugned order?
That is not the impugned
That's
order.
the impugned order in another CO which is pending, my lord.
That was in 2024 till date. No
No,
steps
no,
have
we have
been taken
mentioned,
in
tried
that
to
CO.
mention that matter, my lord. There is another CO pending. We have challenged that order. That CO could not be, for some reason, my lord, the CO could not be taken up till today.
Do you think that
That order will come in the way, if that order,
It has not been moved till date from 2024. The
Lord
CO is
Counsel,
pending.
do both of you think that can also be disposed of along with this one?
yes, my lord, at least.
Can it be if
My lord, it's a
That's, my
there is
lord,
consent?
I mean, actually, it's only
I have no objection to that. Only difficulty is that is of 2024.
Hmm. Hmm.
So whether can be disposed of by my lord, that has to be seen.
এই চলো আমাদেরকে
It has to be, if I may suggest, if this court allows me, what in this situation, what is to be done, we have to mention it before that court. That this, my lord is in session of this matter, and we have to get it released and then assign it to your lordship.
prior to that, I
Will have to see whether it can or not.
I have to.
Because these are assigned matters.
That's the otherwise, this
Yeah,
matter also has to
after
be.
this order, things have happened at the court below also. Further applications were moved.
If that order is, if that order goes,
My lord,
then
no,
this CO also goes.
no stay for 2 years. Only my lord will appreciate this much.
My lord knows the burden of this court,
Not mentioned once also, my lord. At least I was not given notice.
That's in the.
on the part of the court, the court will have to also receive instruction.
What can be done? I can always mention in that court. It's before court number 6. I can mention before that court tomorrow morning. My lord is in session of this matter. If that matter can be released, or if that court doesn't allow, then I have to mention before your lordship. If your lordship releases, I have to take that matter to that court.
Possibly determination is with Mr. Justice Dinesh Kumar Sharma.
Court number 2.
It has been matters where
Yes, it was mentioned
matters
there.
can be
Today
put-
morning we have also tried to mention, I believe.
the matter is not in the list.
Justice Sharma ছিল
না, আমি ধরে রাখতে বলছি না, কিন্তু মেনশন করে এটা করাতে হবে তো।
আমি বলে দিচ্ছি তোমার
For that, এই চলো,
that. I'll say my difficulty, I'll express my mind, I have been advised to get admitted in the hospital. I'm suffering from hepatitis, acute, from last 11 days. I think I will be admitted tomorrow. I will be getting myself admitted, and it will take 2 or 3 weeks now. I was indicating, if that's the difficulty, if I get admitted, I have the prescription and everything.
My lord will only admit the
mention
personal illness. I have nothing to say. I cannot say anything.
I will take 4 weeks. After keeps it after 3 weeks, I'll come back after 3 weeks to the court. I will be taking off for 3 weeks. I'm not keeping well. This is not a matter. Something will happen tomorrow.
My lord will only admit this revision. That is my humble prayer at the moment. It can be admitted.
It can always be admitted. Let kindly hears it. Kindly hears it.
it is being admitted.
On merits, kindly hear it for once. If it falls to the court, my lord, that was this order which I have challenged, that is also relevant. My lord will pass necessary orders. Let them place the case.
Let us take.
My lord will see page.
So
one.
both of you have showed your intention to purchase the share of the other co-sharer.
I was
You have intended to purchase 1/3 and they have intended to purchase 2/3.
here
Thereafter,
January 5 order, which is under challenge in the other revision application, which my learned friend just mentioned. This is at page 133.
fifth of January 2024.
January 2024.
That is the impugned order
No,
before that
in the other revision.
in the other
application, my lord.
revisional application.
My lord will kindly see page 139.
Yes, 139.
In that view of that matter, towards the second paragraph, in that view of the matter, it is found that the petition dated so and so made by the plaintiff having 2/3 share in the property is entitled to be allowed, and the defendant should be directed to sell her 1/3 share to the plaintiff. However, it is made clear that the transfer will be on the basis of the present market value of the property to be obtained from the appropriate government authority. So this order was made. He was directed to sell his share to me. But immediately thereafter, my lord, I obtained the valuation. Page 148, there is a valuation. and I had put it in with the learned court. Thereafter, my lord, I filed.
এই কি বলে ধুলো এ কি কথা ধুলো মুছে দিতে হবে ধুলো এখন না হয়ে যাক ফাইল দেবার আগে দেখে নেবেন yes valuation is
I communicated
33 lakhs
Mine.
41,250
mine.
yes
I communicated to the defendant, my lord, which is at 147. The 1/3 share comes to around 14 lakhs. Thereafter,
this is the total valuation of the
this is the total valuation. So 1/3 comes to 14 lakhs and odd, which I communicated to them. At page 147, there is a
Okay.
letter.
how can 1/3 be 14 lakhs 33 lakhs 41,000
Land and structure, my lord. So
Acha, this
my
is the
lord,
valuation
42 lakhs.
this is the valuation of the land 33 lakhs
Market value.
41 and where is the valuation of the structure
Well, 42 lakhs is the market value of the whole premises. my
wherein
lord.
it is mentioned
To the top, my lord. This is the 6th column from the top, my lord.
42 lakhs 13,350 so 33 lakhs 41,000 is the valuation of the
land
land only
And then the structure details are given thereafter. Ground floor areas.
total is 42 lakhs
13 lakhs and
for
350.
42 lakhs 13,000
13,350.
350 total yes
We communicate to the defendant, which is at page 147. The defendant doesn't take steps. Well, so we file this application, which is at page 151.
1 minute $151
151, we file this application. The prayer is at 153. Under the facts and circumstances stated above, it is most humbly prayed that the sale deed in respect of the 1/3 share of the defendant of the suit property, as per schedule below, be executed by the registrar of this learned court. This is the application which was dismissed. They had filed their written objection there too. This application was dismissed, my lord, by the impugned order, and I have come up against it.
Achha.
The impugned order is an order dated November 22, 2024.
Number 139.
139, 139.
এরপরের থেকে কিন্তু প্রত্যেকটা পরিষ্কার করে দেবেন এরকম ধুলো শুধু দেবেন না এই কি কথা এই জন্য এত কাশি টাশি হয়
This is the order number 139.
22nd November
22nd
2024
November 2024. The case record is taken up for passing order on the application by plaintiff dated 30th August 2024 for direction to execute the sale deed in respect of 1/3 share of the defendant by the learned register, City Civil Court, Calcutta, in favor of the plaintiff. It is stated in the application that the instant partition suit was decreed initially preliminary form on 16th May 2011, declaring the share of the parties, that is share of the plaintiff as 2/3 share and share of the defendant as 1/3 share in the suit premises. Engineer commissioner filed a report with observation that the suit is not partible. Suit property, it should be suit property is not partible. Several applications were filed by the parties. Parties could not come to amicable settlement, and plaintiff filed application for public auction. And finally, this court, with order number 128 dated 5th January 2024, directed the defendant to sell her 1/3 share in the suit property to the plaintiff for consideration money of rupees 14 lakhs and odd, which is the valuation obtained from the Office of Register of Assurances, Calcutta. It is stated that the defendant did not comply with the order, and therefore the sale deed executed by the learned register plaintiff. Plaintiff undertook to comply all orders for drafting and execution of sale deed. Defendant filed WO dated 23rd September 2024. It admitted that engineer commissioner reported that the suit premises is not partible. It is also admitted that the parties could not come to amicable settlement. It is alleged that the plaintiff is trying to evict the defendant. It is admitted that under order 128 dated 5th January 2024, defendant was directed to sell her 1/3 share to the plaintiff for rupees 14 lakhs and odd. It is stated that the defendant is currently residing in her 1/3 share since long.
Mm.
She never asked for sale of her 1/3 share to the plaintiff. Instead, she is willing to purchase 2/3 share of the plaintiff at rupees 28 lakhs and odd.
Mm.
Perused record. Order number 128 dated 5th January 2024 is a detailed order.
1 minute.
My lord.
You intend to purchase at no 14 lakhs
14 lakhs.
exact amount 14 lakhs
14 lakhs 4,450.
450. So and you intend to purchase at rupees 28 lakhs 8,900, the double the amount, exactly double the amount, not 1 rupees more.
No,
So
that's there.
Hmm.
You know, there is some other difficulties.
ठीक है. Yes, that is record. Order number
Order number
28.
128 dated 5th January 2024 is a detailed order where after examining all aspects, this court directs the defendant to sell her 1/3 share in the suit property to the defendant upon receiving the consideration money. Thereafter, under order 129 dated 5th February 2024, plaintiff filed e-assessment slip showing the market value of the suit property from which value of 1/3 share was taken at 14 lakhs 4,450 and the defendant was directed to take steps for preparation of sale as per order dated 5th January 2024. Now the plaintiff has filed another application for execution of sale deed. Order 21, Rule 34 of CPC. Now he says I have to file an execution, my lord. Respectfully provides for execution of documents and sale deeds under a decree. The court cannot invoke provisions under Order 21 of the CPC unless the DHR files application for execution under Order 21, Rule 10 of the CPC. Parties are to take recourse and take steps as provided in the CPC and no otherwise when the procedures are laid down in clear terms. So I do not find any ground to bypass such provision which may prejudice the rights of the other party. Hence, the application is dismissed. But my humble submission is there are orders already here for execution of the sale deed. Defendant has already been directed, my lord. These orders can be passed, my lord, in my humble submission by the learned court below.
Earlier, there was an order passed by the court to execute.
5th January.
5th January.
And then an order of 5th February.
No, wherein it has been mentioned in the in this order also it is mentioned. Okay. Order number 128 dated 5th of January 2024.
And then
is
5th of February.
Where after examining all aspects, this court directed the defendant to sell a 1/3 share in the suit property to the defendant upon receiving the consideration money. Thereafter, under order 29. Oh, yes. Yes. Yes, sorry, counsel. Next.
So, order 128, 5th January says that the execution has to take place.
Yes.
Then the order also refers to another order 129 dated 5th February. I filed an assessment slip and defendant was directed to take steps for preparation of the sale. So, my lord, there is nothing which really prevents this court from making an order directing the defendant to sell. The registrar may be appointed if the defendant fails.
So ultimately, what has been done?
Ultimately, the application was dismissed saying I should file an execution application. After having passed a series of orders, directing sale, taking my e-assessment slip, then again directing the defendant to sell, I am being directed to go to the execution, my lord. My humble prayer is the learned court below has powers to pass an order directing sale. Because my lord knows the partition suit reaches its finality only on partition or, my lord, auction sale. The partition suit has not reached its finality. There is no scope for going to execution at this stage, my lord. This is all I am submitting.
What is your objection, learned counsel?
My lord.
First of all, do you admit as regards to the order number 128?
That is under challenge.
That is under challenge.
That is under challenge. Well, let me show you what order 128 says. Will kindly comes to page 133 once. The main Millard.
Counsel, then both will have to be taken up together.
Absolutely, my lord. I was not standing
by this court or by that court, whichever.
Will kindly cease.
But I am not for a moment standing in the way. I was only saying this petition may be admitted and both can be taken up together. Otherwise, there might be a conflict of decisions in my humble submission.
Will kindly comes to page 139 once.
In that case, this court will have to mention in the order that that record be also.
If that is possible.
Millard allows me.
At this juncture, it is not possible. That's why it will be possible on the next date.
I understand.
Will kindly allows me 2 minutes.
I'll have to seek.
Kindly allows me 2 minutes. Kindly comes to page 139 once.
Page
130. That is 128 order. Order number 128. That is the order that has directed me to sell my share in the property. Page 139, really.
139.
Not the second the second last paragraph.
The
The defendant is direct to sell one-third share in the suit property to the plaintiff upon receiving the consideration money as per the present market value. Upon receiving the money, not before receiving the money, not when the money was offered. I will pay you. Come and execute the deed. I will pay you on that day. It's not that. The order was that you pay and then you ask for a deed. This is one. That was never complied with. That may be there. Next,
General fact is that after obtaining the money, consideration amount, the seller executes the deed.
That is all. That is one point. This order is now under challenge. Next, can the after passing of the final decree, final decree has been passed, that has been annexed. The court without an application, to my humble submission, this is my understanding, the court is functus officio. Then this order which has been passed, that is also bad in law. The order that has been the passed, there is an order impugned, that is right. Let the court, when they file an execution, if I don't buy now, if I don't pay, they can do it only by an execution. They cannot show even one provision that after a final decree has been passed. After a final decree.
Let the court be clear. What is your intention?
Well, my intention is now we are not paying. The amount which was offered back then was high. Now it is low. The direction is on the market value. The market value has come out to be low. It was earlier it was given 44 lakhs. Now it is coming down to 14 lakhs.
No, 44 lakhs. That is the entire.
Previously there was an offer for 66 lakhs and 41 lakhs. 44 lakhs, I believe.
Well, then parties were trying to amicably settle.
There were offers and counter offers, 66, 44.
The settlement did not happen. The learned court said, get the market value. So I am offering to pay the market value. And so far as the final decree party is concerned, when it is argued, I will show, my lord, there are instances when in a partition suit, with the deepest of respect, my lord, more than one final decree is possible. The Honorable Supreme Court have come with the judgments also. My point is, my lord, after the final decree was made, admittedly applications were filed by both the parties. Sorry. Admittedly, orders have been passed by the learned court below. But this is because the final decree did not conclusively determine anything, my lord. Only says.
So crux now is that the amount.
One more thing. On the law point, the orders have been passed by the bench who was dealing with the suit. In execution, city civil court, executions are taken up by the registrar. That is also there. The orders have been passed by the registrar.
Today, my lord will envisage there is a final decree which only says property cannot be partitioned, says nothing more. So this is not the final decree, in my humble submission, which conclusively determines the partition suit. There has to be further directions. My lord knows in a partition suit, if it is impartible, my lord, sale has to happen. So the final decree ought to have included something, my lord, with the deepest of respects. Since it did not include that caveat that there has to be a sale or an auction sale or sale inter se the parties, my lord, this is the reason applications were filed by the parties. Today the defendant comes and says that these applications are without jurisdiction, even my application. But the fact is, both of the parties have filed applications, orders have been passed. And my lord, in my humble submission, rightly so, these are all supplemental to the final decree. There are instances even when the Honorable Supreme Court has said supplementary final decrees are possible, my lord, in a partition suit, because partition suit is a suit which has a different character than a normal suit, my lord. And my lord, nothing has been conclusively determined. The property is impartible. I come with a suit saying let the property be partitioned by metes and bounds. Only decree I get is property is impartible.
Now,
it has to be a logical conclusion.
Your client is repenting now.
Yes, that's the difficulty. And one more thing, Milord.
That has failed.
Milord, if the property they don't want to keep, I don't know, Milord, they want to keep the property or not. Milord, if the property now goes for an auction sale, Milord, this will fetch more money for me, but they can always participate. Milord, what's the difficulty? They can always participate and buy that share.
There are already orders of.
Milord, they have also opted for partition sale, auction sale at one point of time. Well, if they say this is an agreement, well, they have to enforce it by another proceedings. If they say no, well, they are giving it a character. If they say this is an agreement, well, either by an execution or by a, well, this cannot be done. Well, by a court, the orders have been passed. Well, two persons cannot confer jurisdiction of a court which does not have it. But
I
this
say
is
the
like
court has not
conferring
lost its
jurisdiction, my lord.
jurisdiction.
Two persons wrongly conferring jurisdiction on a court.
But
But my lord can understand difficulties are there.
fact is that that revisional application will have to be called for. But
My lord, what I will be doing, my lord,
let there be someone representing you
where?
on the next day when this order will be passed. That
What I say,
this-
when
this
there is no hurry to this purchasing the property. Will kindly grants me 3 weeks. Will keep it at the top. Will grant me 3 weeks. Will September 5th,
My lord, if my lord feels.
7th of
this order
September
is
at the
a pro-
top. By that time, I'll get that matter. If possible, if the court will not pleases so, will I get the matter released and will get the matter assigned. Now, what
Learned counsel.
My lord, things have to be brought to a logical conclusion so far as the partition suit is concerned.
That should be kept in mind on behalf of both the sides.
There's an order of court which allows me. There is no stay of that order for 2 years, my lord. Nothing was moved, my lord.
There's legal point involved here.
My lord, absolutely.
Whether after passing of that order being number 128,
128.
thereafter 129
My lord, if
can further
my lord,
execution.
well, execution, the question of execution should arise then at a much earlier stage. When what is being labeled as a final decree, then the question of execution should have arisen immediately thereafter. My lord, with the deepest of respects, there are instances when a partition suit does not come to its logical conclusion, further orders are passed so that it can be solved, my lord.
At this present juncture, it can be solved if this one, without passing any order today, if it is kept on Tuesday, in the meantime, this bench will seek an instruction whether it can, by its inherent power, call for the record or not. Having this matter been assigned by
my
the
lord can always, to what I know, my lord can call for it, but my lord would not be able to decide it.
That I leave to your lordship. Your lordship will do the needful.
let it be on Tuesday.
Thursday, if it is possible on Thursday, my lord.
This Thursday.
Next Thursday. Thursday. Next Thursday.
Then the
utmost,
this one will be admitted, and therein that revisional application wherein that impugned order number 12128.
In the meantime, I will also try myself, my lord, to get the matter, my lord, if possible, to get the matter released from that court. If it can be brought to this court and assigned.
On your ground, let the matter be on consent.
Kindly records it in the order. Today's order. Kindly records this CO number in today's order, my lord. By that order, my lord, I'll get it assigned. I'll try to get it assigned. It's on the Chief Justice, my lord.
Let it be on Thursday.
Thursday, my lord.
27th.
27th, my lord.
27th.
Only this petition may be admitted, my lord. My lord has heard this petition in extension. My lord has the power to admit this petition. Kindly admits this petition so that both can be heard together, my lord.
In that order only, the other revisional application whereby order number 138 or 28 has 128 has been challenged.
But that doesn't, in my humble submission, at the moment stand in the way of the revision petition being admitted.
Learned counsel, that will have to be dealt with while dealing this one.
Since there is no stay, but I'll leave it to your lordship. But since there is no stay, possibly there is no difficulty.
Killen, the petitioner and the opposite party are being represented on consent of both sides. Let the matter appear on which date? 27th of October 2026. 27th of August 2026.
Kindly records that this matter, my lord, the other matter, that order, somewhere in the order, my lord, that links to this, and I get it assigned them. In the meantime, you can do that.
On that day,
Grateful.
27th of August 2026 তাহলে এটা কি দেখুন টপে আছে 27th August দেখুন নেক্সট থার্সডে পার্ট হার্ড আছে তো তাহলে পার্ট হার্ডের পরে করে নিচ্ছি after the part heard matters
Well, I'll give the other number. I'll provide the other number to the
you can
number.
To be mentioned. Well, it can be kept as to be mentioned because on that day there is going to be not much hearing. Only matters will be coming to your lordship.
yes after part heard let it be আচ্ছা কেন ওই শুনুন এই নাম্বারটা নিয়ে আরেকটা ঠিক আছে সেইটা রাখবেন ঠিক করে you have provided that number
That is the other number. এই ফাইলটা 24 ওই ডিপার্টমেন্টে থাকবে রুলে থাকবে
শুনুন
এটা কোনো জায়গায় লিস্ট হয়নি তো রুলে থাকবে
এই কি বলে রুল পরে আমাকে দেবেন ঠিক আছে আমি ইনস্ট্রাকশন নেব whether I can call for or not ঠিক আছে ক্লিয়ার হলো তো
ও ওখানে with honors lordship please.
yes next
Item number 11.
item number 11 তাহলে ওই এক অর্ডার হবে none is representing the petitioner next
Item number 12.
same order item number 12
Item number 13. For the petition.
yes
This is my application for the expeditious disposal of the application under section 8 of the West Bengal Land Reforms Act along with two applications, my lord. But my lord, during the pendency of this application, those two applications has been disposed of.
Gotcha.
So my lord, I'll be praying only for the expeditious disposal of that application under section 8 of the West Bengal Land Reforms Act, my lord.
filed in the year 2025 the learned counsel representing the petitioner submits that he is seeking early disposal of the preemption miss case 16 of 2025 which has been filed under section 8 of the West Bengal Land Reforms Act 1955 full stop. Considering the fact that the said preemption miss case has been filed just in the year 2025, this court is not inclined to pass any order for expeditious hearing of the said preemption miss case. As such, the prayer is rejected. Disposed of, rejected also disposed of. Next.
Item number 14.
Can I Victor for the petition? My lord, I'm led by Mr. Tanmoy Mukherjee. My lord, this is of difficulty. My lord, may I just pray for this matter to be listed on next Thursday? My lord, he has some difficulty.
Next Thursday,
He will be out of station for till the Wednesday. My lord, that is why. My lord.
you represent the petitioner or petitioners?
Petitioner.
Petitioner.
Suit for declaration. My injunction prayer was initially refused, granted in appeal, again refused at the time of final hearing of the appeal. Against that order, I have come up to lordship.
No. Ad interim temporary? Ad
Refused.
interim temporary refused.
Refused by the trial court. I carried
The
in
trial
appeal.
court.
Appeal
Therefore,
court granted.
Acha, against the ad interim temporary injunction, you had preferred miscellaneous appeal.
No, against the rejection of my ad interim order, I preferred an appeal. In appeal, ad interim stage, my prayer was granted.
Granted. Thereafter, on
Contested
contest,
hearing, it was
it has
refused. Refused. Against that order, I am before your lordship.
The learned advocate representing the petitioner seeks an accommodation on the ground of a senior. Full stop. Let the matter appear on 27th.
I'm grateful. One more thing, Manoj, there was a caveat. I have served. Let that much.
Sir.
I have served. This is the affidavit of serve.
The learned advocate further submits the caveat has been filed, and accordingly, copy of the revisional application has already been served. In this regard, affidavit of service has been filed. Let the affidavit of service served.
Yes, my lord, I have.
No. Have you gone through?
No,
Whether
my lord,
served
it's
or
not got the postal receipt. I have served upon the learned council receipt.
council?
Council caveat.
Last time. Be kept to the record. Let the matter appear to Rohit Chage.
I'm
27th of August. Next.
Number 15.
I am for the petitioner, my lord.
Yes.
Opposite party filed a title suit, my lord,
Yes.
against the civil judge.
Suit for
Suit for eviction, my lord.
eviction.
My
You are the landlord.
I am the opposite party.
Tenant.
Tenant.
Eviction on which ground?
Not non-payment of rent, my lord.
Only default.
My lord.
That is the sole ground. Yes.
Thereafter, my lord, I filed written objections and my written statement, and my lord, I also filed section 7(2) petition, my lord, challenging this. And after 6 years, my lord, the petitioners filed the
The impugned order dated 29th of October 2025
2025, my
is
lord.
in respect of 7(2) application.
My lord.
Place.
7(2) application rejected, my lord.
Yes.
And
What is
allowed
the ground? Ground for revision?
page number 7, my lord.
Hmm?
My lord, several orders are accepted by deposit the monthly rent. My lord, I deposit the monthly rent, and my lord, several time.
Which paragraph are you placing?
3, my lord.
Paragraph 3.
There are 3, page 8.
Question.
Ground.
Ground number 3, yes. Place it.
And my lord, also
For the
page number
learned
4,
court in
5.
its 1 minute. For the learned court in its several orders has
Several
accepted
the
the
deposit the
deposit.
monthly rent, including the challan filed by the petitioner with effect from August 2028. And my lord, in spite of the learned court rejected the petitions under section 7(2) of the said act without any valid reasons, my lord. And court accepted this several time, my lord.
Place the impugned order and the ground, specifically the ground on which it has been rejected.
My lord.
Learned counsel need not place. I'm going through. Order number 30. Completed the service of summons. Appear for the that is not taking 1 month from that is not taking 1 month and sorry the summons from that the number 3 also admitted the treaty project is admitted when for the suit premises 2000 ran from May 2016 to what for the without 10% without the 10% interest and I'm taking into vendor this Senate Council, what do you have to say as regards to the sentence with the word however, internal page 2, the second last paragraph in the middle of the second last paragraph. Internal page 2 of the impugned order. Have you got the impugned order? Internal page 2, second last paragraph. The sentence commences with however in the instant suit. Place it. Have you got it? Have you got the
39, my lord.
Have you got the impugned order? Order dated 29/10/2025. Internal second page.
Second page.
Second last paragraph. Middle portion. However, have you got? However, in the instant suit, the service of summons upon defendant number 3 has been completed within 21st of July 2016. But she appeared before the learned court on 2nd of August 2018.
He completed service of summons upon the defendant number 3 has been completed. But my lord, endorsement is not in his own name, my lord. He is not received the service of summons, my lord. Someone received someone, my lord, but not the plaintiff, my lord, and not the defendant. In her written statement, he also stated this.
In the petition, in this 7-2 application, wherein it has been stated that the endorsement was not of the tenant, defendant. Where is the application? It is in page?
Page number 16, my lord.
16. Yes. In which paragraph you have stated?
নালিশি প্রেমিসিস দখল বাদীপক্ষের লওয়ার প্রয়োজন হয় বাদীপক্ষ উহাদের উক্ত
Which paragraph are you placing?
Second para, my lord. Page,
Okay, নালিশি premises paragraph 3.
Para 3.
1 minute. Paragraph 3. Mr. Bhattacharya, you're representing the opposite party. Landlord.
Milord, landlord, milord.
Kindly be seated.
Yes, milord, but revisional application, as I find, milord, is otherwise defective. All the parties are not made here in the parties who are in the plaint.
Mousumi Moitra is the sole tenant.
Kindly see, milord, 13, page 13.
1-3. Yes.
Only defendant number 3, milord, Srimati Mousumi Moitro is the milord petitioner. Then 1 is there, 2 there, 4. my lord, I could not find, my lord, them as parties. And my lord, who are the opposite parties are the, my lord, my clients Ram Prasad Purkai, Devo Prasad Purkai, Shant, they are the, my lord, landlords. Because otherwise, my lord, they have to be only one party can challenge, but the others have to be pro forma parties.
Third council reply to this one.
I'll serve other party, my lord.
They have to be implicated
Grant leave
as
for-
pro forma.
Grant leave.
Thereafter.
The service will not be required, my lord, only addition, because they are all the dependent, they have not.
They are brothers and sisters.
Same, yes, sisters. Same family members, my lord.
You are the advocate on record
My lord.
during the course of this day. Nin. The learned counsel representing the opposite parties submits that all the tenants have not been implicated in the present revisional application. Full stop. Paragraph. The learned counsel representing the opposite, representing the petitioner is at liberty to rectify the cause title of the divisional application during the course of this day. Let us hear it. শুনুন শুনুন এটা ওনাকে দেবেন এটা ওনাকে দেবেন, উনি ওই যাদের অ্যাড করা করে দেবেন ফার্স্ট টাইটেলে, ঠিক আছে? লিভ দেওয়া রইল, ঠিক আছে? ইয়েস। Yes, Lord Counsel. It is her submission that the endorsement does not bear the signature of the tenant.
Where? In the summons.
In the summons.
Yes, that this was, my lord, hard on, my lord, evidence. Evidence was taken. They should have pointed it out. But 227 court, my lord, cannot go into these, my lord, factual disputes.
Whether this point was raised.
My lord, I could not find that.
Section 7.2 application. In the 7.2 application, whether this point has been raised.
This third page of the order.
No. Let us first go through the application. Wherein it has been mentioned.
Page number?
Page number 28, my lord. Postal pioneer দ্বারা মিথ্যা রিটার্ন জারি দেখায়া রাখিয়াছেন।
Page 28, which portion are you placing?
Page 25.
Page 25.
This is written statement.
Written statement.
In the application under section 7, subsection 2 of the West Bengal Pension Tenancy Act. Where is the application?
35.
Counsel, do you have a senior? Huh?
I have senior, my lord. Premises Tenancy Act 7 to
Page 35.
Page 35, my lord.
Page 35.
Yes.
7.2 application. Yes. In the said application, where have you mentioned? Where have you challenged?
It was not stated, my lord, but written statement it was stated.
And my lord, service was affected both ways. My lord, through process server also. Time will run, my lord, from that also. After Milord, this Chamaria's judgment has come, Milord.
In the application, you have not stated, nowhere. So, what wrong has the trial court committed?
Milord, another, there is also non-compliance on Milord 10% deposit.
That is second part.
No, that is maintainable. 7.2 is maintainable provided this is Milord 7.1 is
No.
compliant. This is part of 7.1.
On two grounds, it has been rejected. Firstly, on that
Time?
someone been received in the year 2016,
Yes.
May 2016, yes, July 2016, and they entered appearance on 2nd of August 2018. And the second one is 10% interest.
Even if Milord the time period is not given, Milord, 10% interest that is apparent from the record. That cannot be cured. Consistency after that. Kindly see 7.1.
এই প্রেমিসিস টেনেন্সি অ্যাক্টটা কোথায় গেল? প্রেমিসিস টেনেন্সি অ্যাক্টটা দিন তো। ওয়েস্ট বেঙ্গল প্রেমিসিস টেনেন্সি অ্যাক্ট 1997। এটা 1956, এটা পুরোনোটা। এটা 1956, 1997। Yes.
Kindly see one. On a suit being instituted by the landlord for eviction of any of the grounds referred to in section 6, the tenant shall, subject to provision of subsection 2 on this section, pay to the landlord or deposit with the civil judge all arrears of rent calculated at the rate at which it was last paid up to the end of the month previous to that in which the payment is made, together with interest at the rate of 10% per annum. After compliance of this, then comes 7.2. 7.2 cannot be touched without compliance of this. Whether Milord, Milord, let us, for the sake of argument, it is taken that this summons were really not served. Very well, not served. What about compliance of 7.1 deposit of area rent? And these are all interlinked with each other. It's not or. Every step is connected with each other.
Lord Counsel, any reply? Not allowed, rejected. But you comply with the Liberty Learned Counsel during the course of this day.
Submission 2016 suit. Some expeditious hearing. As expeditious. 16 suit. Till 26 now, Milord, 7.2 has been disposed. Some observation regarding expeditious hearing.
The Learned Counsel representing the petitioner tenant submits that summons was not received by the tenant and there is no endorsement to that effect. Full stop. As such, one of the ground on which the application under section 7 subsection 2 of the code of of the West Bengal Premises Tenancy Act 1997 has been rejected. Mhm. Hmm. As the, as such the tenant could not comply with the provisions laid down under section 7 subsection 1 of the West Bengal of the said act, 1997 act of the 1997 act, ওই যে 19 West Bengal Premises Tenancy Act 1997 বলেছি না, ওখানে hereinafter to be referred to as the 1997 act, ঠিক আছে? হলো। She further submits that in the written statement it has been mentioned that there was no endorsement of the tenant in the summon, but in the application under section 7.2 it has not been mentioned, full stop. On this ground, the rejection of the trial court is not in accordance with law, full stop. Per contra, next paragraph, per contra, the learned counsel representing the landlords,
Yes.
opposite parties, landlords, submits that apart from depositing rent, a tenant is to submit 10% as interest per annum in respect of the area rent, but the petitioner tenant herein has not complied with the said proviso laid down under the 1997 Act. Full stop. As such, the impugned order dated impugned order number 109 dated 29/10/2025 is in accordance with law, full stop. And the revisional application is deemed to be rejected, full stop. Paragraph. On hearing the learned counsels representing the petitioner tenant and the opposite parties landlords, and on perusal of the impugned order and section 7.1, section 7 specifically subsection 1 of the West Bengal Premises Tenancy Act 1997, it transpires that the petitioner tenant has paid the area rent from May 2016 to August 2018, but has not deposited 10% interest per annum, which has been laid down under section 7.1 subsection 1 clause A, which states as follows. বলে ওই section 7 subsection 1 clause A টাকে প্লেস করে দেবেন, ঠিক আছে? হ্যাঁ, নিশ্চয়ই বই নিয়ে যাবেন। It is also fact that as regards to receipt of summons, nothing has been agitated by the learned by the petitioner tenant in the said application filed under section 7 subsection 2 of the said act. full stop. Considering the non-compliance of the provisions laid down under section 7 subsection 1 clause A of the 1997 Act, the order under challenge has been passed, and as there is non-compliance of deposit of the 10% interest amount, so the application under section 7 subsection 2 of the 1997 Act has been rejected. Full stop. According to this court, full stop. This court is of the view that the impugned order does not require is in accordance with law and is in accordance with law and does not require interference. Full stop. Hence, the revisional application is rejected. Full stop. সেটা তো হবে। At this stage, the learned counsel representing the opposite parties, landlords, submits that the suit for eviction is of the year 2016, and just in the year 2025, section 7(2) application has been disposed of. And at what stage is the title suit? The eviction suit?
Framing of issues.
Framing of issues.
Yes, may I kindly see Miller.
No, issues have been framed.
12th November 2025 for framing of issues.
12th November 2025. Nearly 1 year has passed by.
Without stay, they were successful, Milord, in without any order of stay.
কি হয়েছে সাবমিশনে? And issues have been framed in such situation. The learned counsel seeks an expeditious disposal without there being any prayer, learned counsel.
My prayer 227. 27.
Let
what you can give, Milord, as expeditious, subject to convenience of the learned. So,
Item number 16.
16.
Appearing for the opposite parties, my lord, we have not received the copy of this valuation application yet.
Well, I don't know whether any caveat is there or not. I think no caveat is there.
But I don't have any instruction on that.
But in spite of that matter, just yesterday I have received the I have been briefed in this matter. I need some time to
place the matter before your lordship. My lord, Miss Appeal filed against the order of preemption, my lord. 8, and the appeal filed under section 9. 8, the petitioner of he obtained an order under section 8. A part decree of preemption grant by the learned trial court. Thereafter, the part decree, it was challenged in another misappeal by the petitioner, and that misappeal allowed wholly in favor of the petitioner. Thereafter, my lord, the opposite parties herein, my lord, they they filed a civil revisional application as by saying that presently they are the owner in respect of the property.
Yes, my lord. Yes, my lord. So, yes, my lord, all of them.
Right, they are the pro forma opposite parties. I don't think that at the same time for the opposite parties and pro forma opposite parties he will appear. I don't think at the same time. Well, may I check the file that whether caveat is there or not? File
served upon them, full stop. Considering the said fact, the learned.
Well, when the matter was filed, my lord, there was no caveat.
There was no caveat. Petitioner or petitioners?
Well, the petitioner.
Petitioner is directed to serve. The learned counsel representing the petitioner is to serve copy of the revisional application.
Let the matter heard by your lordship on that event. If it is admitted by your lordship, I shall serve. But no caveat is there, my lord. Only because of they have find this
Do you intend to proceed today?
Today I am not in a position to proceed this matter, my lord. I am seeking.
You serve it upon.
Man.
Um,
Fix any day, my lord, in the next week.
When? Next week.
Kindly fix it on 27, my lord.
27th. তাহলে ওই ওটার পরিপ্রেক্ষিতে করুন the learned counsel representing the petitioner is to serve copy of the revisional application upon the learned counsel representing the opposite parties. Within this week, let full stop. At this stage, the learned counsel representing the petitioner seeks an accommodation. Let the matter appear on 27th.
I'm grateful to you.
Next.
Item number 17.
Mainly I for the caveat or opposite party matter.
You have received copy?
Yes, yes. Well, Mr. Tanmay Mukherjee leading this matter, my lord. He is engaged court was 6:52. I'll make it note today. Can take up tomorrow, my lord. He just
Earlier on the ground of Mr. Mukherjee.
No, this is first time we call him.
Not in this matter.
Oh, okay.
In an earlier matter, on the ground of Mr. Mukherjee, some accommodation was sought for, but that was for a week, submitting that Mr. Mukherjee won't be available.
Oh.
He is in court.
Yes, in court. Can take out it then. But they not can take it up any day or after Monday, but I'm suffering throat infection.
Can I take on next Friday, my lord? He may not be available on.
This is what type of evidence?
Tomorrow can.
No, when to be taken up?
Next
week.
Next week.
Next Friday.
Wednesday, any day. I'm not sure.
এই, বলুন তো কবে দেওয়া যাবে? 24th, 25th, 27th, 28th.
28, it may be taken on 28.
Why not 27th?
27, I have so many matters have been fixed in court number 17, 15, 30.
কি বলে 28th রাখুন।
Individual service may be kept with the
আচ্ছা, তাহলে প্রথমে নিয়ে নিন affidavit of service has been filed, let it be kept with the record. প্রথম হলো, তারপর the respondent, the opposite party or opposite parties.
Party. Only one. Opposite party. একজনই তো আছে।
না, দুজন
The opposite party.
I am one, তাহলে।
Is opposite party.
একজনই আছে। Only one.
Yes, correct. But I'm sorry.
Section 8 of the Land Reforms Act.
Yes.
Both the learned counsels representing the petitioner and the opposite party seeks an accommodation for a week. Let the matter appear, okay, on consent of both sides. Let the matter appear on 28th of August. On that day, don't seek.
No, then I'll do that.
If Mr. Mukherjee is not available, then
Yes.
28 তারিখ. Next.
Item number 18.
My lord, I am for the petitioner. My lord, this is a suit for eviction of license. Now, my lord, I am aggrieved by the order passed by the trial court.
You are the?
I am the plaintiff.
Plaintiff landlord.
Plaintiff landlord. Now, my lord, I am aggrieved by the order passed by the trial court recalling ex parte proceeding against the defendant. The impugned order was passed on 2nd of December 2025. Kindly seize the impugned order first, then I will place the entire order sheet which I have annexed to show how abundant.
Place the impugned order. Directed that this would be.
Today is fixed for passing order in respect of petitions.
On
filed by-
perusal of the order sheet, it is found that this court is in order dated 27th of November 2024. 4th paragraph. On perusal of the order sheet.
On perusal of the order sheet, it was found that this court, in order dated 27th November 2024, directed that the suit be heard ex parte against the defendant since he had not appeared in spite of proper service of summons. Thereafter, evidence of PW1 was concluded, and after the defendant appeared and filed an application under section 151 of CPC for vacating order of ex parte hearing without filing any WS. Subsequently, meanwhile, my lord, the time limit for filing WS has already expired. Subsequently, on the next day, that is 7/8/2025, defendant filed a show cause application along with WS. After going through the contention of the petition and WO, this court is of the view that every party should be given an opportunity of being heard. Considering this view, and also for the purpose of proper and effectual adjudication of the suit, this court is inclined to allow the prayers of defendant. However, subject to payment of cost of rupees 1300. Accordingly, the petition is allowed with cost of rupees 1300. The order of ex parte hearing is hereby modified and WS will be accepted on payment of cost. Now, my lord,
when the summon was served,
prior to that, my lord, kindly comes to the order sheet. I have annexed the It starts from page 56. Plaint was filed on 25 2023, 20th May. Now, my lord, on 13/3/24, I filed the postal receipts and track report. So it was served by speed post prior to that. On 13/3/24, the postal receipts and track report was filed, and bailiff service was also done. Kindly see is page 35.
From the order dated 13th of March 2024, it cannot be presumed that it was served prior to that.
My lord,
13/3/2024, it cannot be presumed that it was served.
my lord, the track
May I
report
find-
was, it contained the delivery report.
Whether delivered or not,
Yes, that is not,
that is not reflected in the
it
order.
is not reflected from the order sheet.
However,
But
from 21st of May 2024 order,
yes,
as per bailiff report, summon duly served upon defendant.
yes, this was the bailiff service. And this bailiff service will be also be available at page 35, my lord. Kindly see page 35.
Tapati
Nivedana-
Ghosh.
Yes,
Tapati Ghoshal.
Tapati Ghoshal receives the summons on behalf of the defendant. She is the wife of the defendant. নিবেদন এই যে অদ্য ইংরাজি 19/8/2023
According to you, it has been received on 19th of August 2023.
Yes. Since then, the defendant was not appearing before the learned trial court. No written statement filed. Thereafter, the court gave abundant opportunity for appearance to the defendant. And when the defendant was not appearing, the court proceeded ex parte.
Let it be served. Let it be served upon the opposite party.
Lord,
Name. The learned counsel representing the petitioner landlord. By placing the order in the dated 21st of May 2024, submits that as per the bailiff report, summon was served upon the defendant and has also placed page number 35 of the record, wherein there is endorsement of Tapati Ghoshal dated 19/8/2023, and submits that that Tapati Ghoshal, being the wife of the opposite party tenant, had received the summon on 19th of August 2023, and in spite of that, the tenant had not cared to appear before the court, and thereafter after several opportunities, the eviction suit, being ejectment suit number 88 of 2023, was fixed for ex parte hearing. When it was fixed for ex parte hearing, right order dated,
my lord,
27th of November.
Yes, yes.
Wide ordered class check holo. Ex parte hearing, wide order dated 27th of November 2024, and subsequently evidence of the witness on behalf of the plaintiff was completed, and thereafter just on 7th of August 2025,
On the date fixed for argument.
7th of August 2025, that is on the date fixed for ex parte argument, the tenant opposite party tenant filed written statement along with show cause. They had filed, the tenant has filed only written statement along with show cause.
Yes.
Ex parte vacating petition?
Ex parte vacating petition was filed after that. And that is also under section 151.
Prior to that, an application under section 151 CPC for vacating order of ex parte hearing without filing any written statement. So it was filed prior to that.
Yes. On
last sentence. Written statement, which has been accepted by the learned trial court, subject to payment of cost of rupees 1,300. 1,300. Being aggrieved by and dissatisfied with the order of acceptance of the written statement, in spite of fixing the matter for ex parte argument, after giving several opportunities to the opposite party tenant, the petitioner landlord has been affected severely. As such, the petitioner has been compelled to file the revisional application. Full stop. Consider the submission of learned counsel representing the petitioner. The revisional application is required to be heard on the ground as to whether the trial court has been within the provisions of law while accepting the written statement filed after long gap, filed beyond the statutory period of filing the written statement. Full stop. As a copy of the revisional application has not yet been served, the petitioner is directed to serve copy of the revisional application upon the opposite party. Full stop. When?
My lord, 7th of September or any day thereafter. Meanwhile, I will serve.
How much time it will take? It is of
1 week to serve, my lord.
It is Haridevpur, Kolkata.
Yes. I require 1 week's time to serve, my lord.
Let the matter appear on 7th of September. Let the matter appear on 7th of September. আচ্ছা, আর যখন এই সার্ভিস করতে বলছি না, and also to file affidavit of service on the returnable date. ঠিক আছে? Let the matter appear on 7th of September.
Great.
Next.
Number 19. 19, I am for the petitioner, madam. In this matter, I find that there is a caveator, but my junior has not served the copy of the caveator, so will kindly allow me to serve the copy and come back on in the first week of September. But during the pending of the divorce suit, that is the petitioner filed an application under section 36 of the Social Marriage Act, but it has been dismissed for alimony. It has been dismissed by the court observation that she suppressed her income. It is not fair. That's why I have come before Lordship. So kindly allow
What
me
is
to
the
serve
what
the
is what is the occupation of the wife?
she is the computer. Now she is running an school, my lord. That is the computer institution. And husband also income, but without determining actual what is. Today is a student 20, tomorrow is maybe 10. It is not a fixed income. But a husband is the duty when husband filed a divorce suit, because the petitioner always desired to lead a conjugal life. But parents, in-laws are not desire her. That's the main problem. Till now, she is interested to live with him.
Have you filed any counterclaim?
Yes.
Restitution?
No, that it has. I have to take instruction.
That is only verbal submission.
That is regarding the marriage suit, divorce suit.
Restitution, you have submitted that the wife intends to reside with the husband. In that regard, you have not filed any
I have to take
application.
instruction, but regarding the I have come before Lordship, that is the alimony dismiss. That's why.
I think it can be heard now itself, as per your submission.
Because I need some documents to have to produce, because wife already applied.
How many students are there at present?
At present, my lord, then I have to take instruction.
What document do you require?
The husband also doing a business. That's why.
Let the husband earn 10 lakhs.
So she has to.
Let him earn 10 lakhs. How much amount? How much amount you are earning?
At present, my lord, I have to take instruction from my client actually. Means there is a caveator, so my lord, I want to serve the copy of upon the caveator. If your lordship allow me.
Although the petitioner has mentioned in F1 that she is earning rupees 5,000 as computer teacher, she has not filed a certificate provided by the employer. You are a computer teacher.
Then I have to take on that basis. My client contention is that court never asked to produce some documents to substantiate that actually what amount she is earning. So that's why I have come before lawsuit to produce all the documents. Not if you have to.
The learned counsel representing the petitioner wife submits that caveat has been filed, but in spite of that, in spite of that, copy of the revisional application has not been served upon the opposite party husband. In such circumstance, the learned counsel seeks an accommodation to serve copy of the revisional application upon the opposite party. Full stop. Within this week?
The first week of September.
Why? You will have to serve upon the learned counsel.
Because this week I
already
have
caveat has been filed.
Yes, that's true.
You will have to serve upon the learned counsel.
This week, Lord, I have some problem, personal problem. That's why, Lord.
So when to be kept?
First week September, as your lordship convenient.
Okay,
I shall have the copy.
As per the submission of the learned counsel representing the petitioner wife, let the matter appear on 1st of September. 1st of September. Next.
In the meantime, I shall serve the copy.
Yes. And to furnish an affidavit. And to furnish an affidavit in this regard on the returnable date. যখনই বলবো না সার্ভিসে তখনই দিয়ে দেবেন affidavit of service করতে হবে. Next.
Item number 20.
Lordship, petitioner is out of station, so for his treatment. Petitioner is out of station for his treatment. I could not contact with his lordship. Kindly.
Petitioner is not required. Only learned counsel is required.
Lordship, I'm taking instruction from his, and I am not in this matter, Lordship. Mr. Shobhan Majumdar is in this matter. He's also not present in the court, Lordship. That's why I'm praying on 10 days accommodation, Lordship.
Cannot be granted.
Then
Submit, reasonable submission should be there. Unreasonable submission should not be made.
Mr. Shobhan Majumdar is not come. That's why give me 1 day accommodation, Lordship.
Who is the advocate on record?
Advocate on record, Sanchari Upadhyay.
Learned counsel,
Sanchari Upadhyay.
when you come to submit,
Sanchari Upadhyay,
when you come
Lordship.
to submit, be aware of the fact.
Sanchari Upadhyay, Lordship.
The learned advocate, the learned advocate representing the petitioner. Suit for land acquisition case. Learned advocate representing the petitioner seeks an accommodation on the ground of the advocate on record. Full stop. Let the matter appear on 28th of August.
Grateful, Lordship.
নাম নিয়ে নেবেন সবসময় নামটা নিয়ে নেবেন আপনারা, বুঝেছেন? Next.
Number 21.
For the petitioner defendant.
Suit for
partition filed by the sister. The father is the predecessor in interest. The father passed away, leaving behind 2 sons, mother and the daughter. So therefore, each had 1/4 share each. An application under Order 12 Rule 6 was filed by the daughter, and said application was allowed, thereby declaring the shares of each of the parties as 1/4, 1/4, 1/4, and 1/4.
So as regards to share, there is
As
no
regards the
dispute.
share, the mother has 1/4, the daughter has 1/4.
Preliminary decree has been passed, declaring one.
Yes, it has been declared so. Now, in the meantime, mother has already passed. Mother also passed it. The mother made a will.
After the
Mother made a will. The will was probated. As per the mother's
in favor of.
As per the mother's will, her share devolved upon 2 sons. Therefore, the share of the son has increased. So we brought an application before the learned court to apprise the learned court about this development. By this application,
you are representing the sister.
No, I'm representing the 2 sons.
2 sons.
2 sons. Therefore, my share has increased. Now that has been turned down by the learned court, which could not have been done. So kindly seize the will of the mother and the probate.
Whether the sister was cited in
Yes,
the probate?
Yes.
On contest?
Yes.
Page number?
And even the sister has thereafter made an application whereby the sister has made a proposal that she wants to sell off her 1/4 share to the brothers at the present day market value. Therefore, I was humbly praying before Lordship, let me serve a copy upon the other side and come back before Lordship. And in the meantime, if Lordship kindly protects me, because the suit is pending. Suit is proceeding.
Yes. Nothing harm will be there. You are in possession, there is nothing harm.
Then I will serve and come back
Yes.
to the Lordship.
Address, how much time do you require?
7 to 10 days.
Within Kolkata?
Kolkata.
Um,
No, she's residing outside. But her Lordship kindly also allow me to serve upon the learned advocate of the opposite party before the learned court below also.
The learned counsel representing the petitioners submits that the property originally earlier belonged to the father of the petitioners, and on his demise it devolved upon the mother of the petitioners, both the petitioners and their sister. Accordingly, 1/4 share was declared in favor of each of them. Subsequently, after the passing of the preliminary decree, the mother also, mother namely
Mother namely, my lord, কি নাম রে?
mother namely Black Dragon also expired, and thereafter and leaving behind a will, which has been probated, and thereby the share of the mother has been granted proportionately to the petitioners. As such, the share of the petitioners have enhanced from 1/4 to how much it has become?
1/3 each.
1/3, 1/3, no, 2/3. No, it cannot be.
More than that.
More than that has increased. ঠিক আছে? No, ওই তাহলে change করতে হবে. Increased from 1/4. As such, the share of the petitioners have increased from being 1/4. Full stop. In this regard, an application was filed on behalf of the petitioners before the trial court, but the trial court has not entertained the same. On the contrary, has rejected the application dated 5/5/2022, being aggrieved by and dissatisfied with the said order passed on 24th of December 2025. The petitioners have preferred the revisional application. Full stop. Considering the impugned order and the submission of the learned counsel, this court is of the view that there is arguable case. As such, the arguable case as to the fact as to whether the rejection of the application dated 5/5/22 by the petitioners being defendants number 2 and 3 is in accordance with law or not. Full stop. Full stop. The petitioners are directed to serve copy of the revisional application upon the opposite party. Full stop. At this stage, at this paragraph of at this stage, the learned counsel representing the petitioners submits that the opposite party is residing beyond the territorial jurisdiction of this country. As such, the petitioners be directed to serve upon the learned counsel, be directed to serve the copy of the revisional application upon the learned counsel representing the opposite party before the trial court. Accordingly, the said prayer is allowed. Let copy of the revisional application be served apart from sending it to the opposite party, also be served upon the learned counsel representing the opposite party before the trial court.
And the name of the mother is Krishna Bose.
Krishna Bose, name of the mother. How much time?
As your lordship will direct, within 7 to 10 days time we can do it.
Let the matter appear on 1st of September. 1st of September. আচ্ছা, ওই affidavit of service we filed on the returnable date, ওটা থাকবে.
Grateful to your lord.
Next.
Number 22.
And I'm for the petitioner. come up in appeal against an order refusing to pass an order of injunction in my favor. Facts are a little checkered. Dear my lord, I purchased a property.
You are representing the, acha, acha.
He's with me. I purchased a flat, my lord, from the plaintiff, defendant number 3 in the suit.
Owner of the property.
Owner of the property at that time. The title deeds were made over to me. There was a deed of gift which comprised one of the title deeds. But after I took possession of the flat, officials from Fullerton now is SFMG, which is defendant number 1, came over and said that that very flat was mortgaged by defendant number 3 in their favor. And they want to attach it under surface. 13-2 proceedings and everything was started. And ultimately they took physical possession. So I filed a section
Ultimately,
17.
they took physical possession.
They took physical possession. I filed a section 17. There, in an application, defendant number 1 put in their title deeds, whatever was given to them by the defendant number 3. So I have a gift deed, they have a gift deed. Now at this stage, I applied for a certified copy of the gift deed because the certified copy will show whose gift deed is genuine. When I compared the certified copy with my gift deed and Fullerton now SFMG's gift deed, it transpires that the gift deed which is with the defendant number 1 is a fabricated one. Apparent discrepancies, my lord, I have said there are discrepancies. Naturally, my lord, DRT dismissed my petition saying I cannot go into the civil matter, you will have to go to a civil court. Although I have moved an appeal before the DRT and that is pending, I filed a civil suit. Suit for delivery of cancellation declaration that deed is void. In that, I moved an injunction application. Now, my lord sees the order. The difficulty that happened was defendants 1 and 2 could be served. 1 is the finance company, 2 is the authorized officer. 3 was my vendor. He was avoiding service. 4 is a third party who has expressed his intention of purchasing in SARFAESI proceedings. 4 really is not important. 3, my lord, I could not serve 3 and 4, and so my injunction hearing is being refused time and again, my lord. The court is, all the learned court below, my lord, is not even accepting put up petitions. My lord, I am told, my lord, possibly service on defendant number 3 could be affected, my lord. But if my lord is
Has been affected or could be affected?
has been affected, my lord, but I'll have to verify. If it is, my lord, leave to keep it next week, my lord, I can come back and say, because if defendant number 3 has been served, there is really no difficulty. Then my lord can direct the learned court below to hear the application, pass an order. My lord, apparent discrepancy, certified
And
copy.
is the presence of opposite party number 4 required?
My lord, it is not required. He is a person who has expressed his intention to purchase in SARFAESI proceedings. And in fact, I'm told today he is also no longer interested in purchasing that. He wants to go away. Because he has found out that the deeds which were given to the bank, or rather the NBFC, are not genuine documents. His presence is not necessary, but maybe my owner needs to be served. The vendor from whom I have purchased, maybe he
Now, in whose position it is now? At present,
is in the finance company's possession.
SMFG,
which was Fullerton India previously.
India Credit Company Limited. When to be kept?
But any day on the week starting 31st, my lord.
31st?
31st, this Thursday, 31st, Monday, my lord.
3rd of September. The learned council representing the petitioner seeks an accommodation and submits that let the matter be placed during the first week of September. Accordingly, let the matter appear on 3rd of September.
Great.
Senior advocate, তখন সেখানে counsel. Next.
Item number 23.
Lordship, in this matter, I am for the Lordship petition. Plaintiff is the petitioner, Lordship. The application for order 26(9) Rule 9, Lordship, for advocate commissioner was rejected by the learned trial court. Considering that the appointment of advocate commissioner is not necessary for the purpose of adjudication of the suit, what happened? Lordship, may I tell the fact? Initially, the plot was, Lordship, CS record was 625.
Dispute as regards to some area.
CS plot along with the, Lordship, RS plot, because in the RS plot, the CS plot divided into three plots, Bata plots. Now, Lordship, dispute started from the
CS was originally one plot.
one plot.
Thereafter, in RS, it has been subdivided into three plots.
Three plots in the RS record of rights. In the RS record of right, under the heading, Lordship, the Khatian, it was wrongly recorded. Thereafter, it was converted into, Lordship, 3 LR plot. But, Lordship, my allegation against the defendant, that the defendant is trying to encroach my plot of land and trying to making construction without maintaining the building rules as per the, Lordship, Municipal Act. Now, thereafter, Lordship, I filed an application for Advocate Commissioner that to compare the CS map along with the, Lordship, RS map and to the present position of the occupants.
Survey past Advocate Commissioner.
Survey past approval. Otherwise, Lordship, it is not.
Nowadays available.
Yes, yes.
In all the courts.
Because some
Scarcity, there is scarcity.
Scarcity, but some now, Lordship, we have came to know that there are several courses has been, Lordship, where the advocates are also, Lordship, doing the courses and appointed. In the Bardhaman district, Lordship, there is a training center for giving. So
earlier there was at BE College, Howrah.
Now, Lordship, there is another college.
Therein the course is closed, I think so.
Earlier occasion, there was, Lordship, really scarcity regarding the survey past Advocate Commissioner.
Now there is no scarcity.
Somehow it is overcome.
So,
so my application was rejected on the ground that it is not the necessary for the purpose of adjudication. But without, Lordship, appointing the survey past Advocate Commissioner, the controversy regarding, Lordship, the
plaint
kindly comes to, Lordship, page
relevant portion.
Kindly comes to, Lordship, page 10, starting from page 10. The relevant portion, Lordship, is page 12. Kindly comes to page 11, Lordship, last underlying portion.
Yes.
Initially, Lordship, may I read it for you, Lordship?
প্রকাশ থাকে যে পূর্বোক্ত বর্ণিত।
Above that, Lordship, the বাদীপক্ষ তাহার খরিদা সত্যাংশ। বাদীপক্ষ তাহার খরিদা সত্যাংশ এলাস স্টেটলমেন্ট রেকর্ড করাইবার ফলে পূর্বোক্ত বর্ণিত বন্টননামা এবং বাদীপক্ষের ভেন্ডারগণের পূর্বাধিকারীর খরিদা দলিল সৃষ্টে ক তফসিল বর্ণিত 1 নম্বর লাটভুক্ত এবং RS 625 LR 1177 নং দাগ সম্পত্তি 16 আনা অংশে 4 শতক এবং 2 নম্বর লাটভুক্ত, Lordship, RS 625/977 এবং LR 1778 নং দাগ সম্পত্তির মোট 3 শতকের মধ্যে 1/3 অংশে 1 শতক যথাযথভাবে রেকর্ড হইয়া তথায় জঙ্গিপুর পৌরসভার কর্তৃপক্ষের নিকট হইতে উপযুক্ত বিল্ডিং প্ল্যান অনুমোদন করিয়া গৃহাদি নির্মাণ করিয়া পরিবারাদি সহ বসবাস করিতে থাকেন, যাহা জঙ্গিপুরের পৌরসভা 17 নম্বর ওয়ার্ডের 164/159 নম্বর হোল্ডিং এ হইতেছে। নাও প্রকাশ থাকে যে পূর্বোক্ত বর্ণিত বিভাগ বন্টন দলিল মূলে অতুল কৃষ্ণ, অসীম কৃষ্ণ যথাক্রমে 2 শতক ও 3 শতক সম্পত্তি প্রাপ্ত হইয়াছেন। তাহাদের মধ্যে অতুল কৃষ্ণ সেন তাহার সত্যাংশে 2 শতক সম্পত্তি রেবাদেবী মহাশয়কে হস্তান্তর করেন, কিন্তু RS সেটেলমেন্টে CS 625 নম্বর দাগ সম্পত্তি এবং RS 16 নম্বর খতিয়ানের স্তরে ঘরে অসীম কৃষ্ণ সেন, মণিকুন্তলা দাস এবং রেবাদেবীর নাম, that all the legal heirs of the, Lordship, 625 and the 6 in the CS record was, Lordship, inserted in that khotiyan. And what will be the actual record of right? And the next line I have, Lordship, explained that মন্তব্যের ঘরে 625 970 বাটা 977 নং দাগে 3 শতক সম্পত্তি রেবাদেবীর নামে মন্তব্যের ঘরে এবং RS 625/978 দাগে 3 শতক সম্পত্তি অসীম কৃষ্ণ সেনের নামে এবং মন্তব্যের ঘরে রেকর্ড হয়, যাহা প্রকৃত প্রস্তাবে 625 নম্বর দাগে 5 শতক সম্পত্তি মণিকুন্তলার নামে। মণিকুন্তলা থ্রু I have, Lordship, derived the title through মণিকুন্তলা এবং 625/970
on which ground it has been rejected?
That this is not necessary for the proper adjudication. And, Lordship, in the next page, I have asserted that they are trying to, Lordship, by construction, making construction by encroaching the portion, page 12. And they also, in their written statement, admitted that if the Advocate Commissioner is appointed, the real picture will come out. In the WS, there is a statement made by the
Objection.
In the WS, but in the
WS. In the WS.
WS.
In the written objection.
Written objection, they have denied this is not necessary. This is fishing out of evidence. So order 26 rule 9 is not maintainable. This should be rejected.
How many opposite parties are there?
There are lordship only.
District Bardhaman.
It is not lordship. It is Murshidabad lordship.
Murshidabad, Jangipur.
It is lordship only one defendant, main contesting defendant, are 2 to 6 are lordship pro forma.
Serve upon them all.
Pro forma lordship.
Chairperson. So how much time? Fortnight.
Fortnight, Murshidabad, so fortnight is necessary.
The learned counsel representing the petitioner submits that an application under order section under order 26 rule 9 of the Code of Civil Procedure was filed seeking appointment of a survey past commissioner. Survey past commissioner, as there is dispute between the parties as regards to the land. Wide the impugned order dated 8/4/2025. The learned trial court has been pleased to reject the application under order 26 rule 9 of the Code of Civil Procedure. He further submits that by appointing a survey past commissioner, the true picture can be disclosed, which will enable the court to come to the just conclusion of the case. Full stop. Paragraph. Consider the submission of the learned counsel. Considering the submission of the learned counsel, this court is of the view that there is arguable question as to whether prayer seeking appointment of survey past commissioner is required or not to come to the just conclusion of the case. As such, the present civil revision will be heard on this issue. Full stop. In such a paragraph, in such circumstance, let a copy of the revisional application be served upon the opposite party.
Number 1.
Full stop. Opposite party as the petitioner is directed to file an affidavit of service in this regard on the returnable date. Let the matter appear on 10th of September.
1 week more is required. Next week is the holiday. Next week there may be 2 holidays. Fateh Daman and lordship, another lordship for Rakhi or something. There may be a bar resolution.
Is there any resolution?
1 day is there, lordship.
So
16th
16th September. Let the matter appear on 16th of September.
Lordship, for evidence, learned trial court takes the matter of evidence, lordship. So limited stay till that period, lordship. Such that, lordship.
Evidence
The evidence is required. Yes, going to be started. Started, lordship. For next date is fixed for evidence.
I've gone through. It is a case of 2020 or something.
Yes. 25, 26, lordship.
Case
26.
Case of
title suit is, lordship.
2020, no?
No, the revisional application 2026, lordship.
Not revisional application. Title suit.
Title suit 2020.
Evidence is going to commence.
Lordship, then lordship, one line be added, lordship, that the on the next date, lordship, the question of lordship praying for stay or injunction be lordship kept open.
That's why I had gone through the
Otherwise,
year.
lordship, if lordship the determination is changed, we will suffer due to lordship. There is no interim order on the.
You won't suffer.
Prayer for lordship asking for a liberty to pray for adjournment. Oh, I will comply, Lordship. I will comply. Great. 88.
আজকে ডেইলি লিস্টে আছে তো?
88
88
যেটা মেনশন করলেন সকালে
সকালে।
স্যার 88 নম্বর আইটেম কালকেও তো ছিল কাল ছিল
কালকে
96 96 এই সকালবেলা মেনশন করেছেন নোটিশ দিয়ে উনি কালকেও মেনশন করেছিলেন
ক্লিপ নেই।
ঠিক থাকবে না জজ সাহেব দেখেছেন 2 PM $88 it was it's appearing for last week it was he tried to mention yesterday he was yesterday minus takes up original side yeah we
Yes,
have
yes,
given
I have
whosoever we know about they have received the notice Millard, no there was no caveat after admission this is appearing this has been released after admission it has been served they appeared we have given notice they have received also for today because the yes all notice given they have received only thing is that matter is tomorrow fixed before the court below and court below said I will not give any further adjournment due to the pendency until unless my lords directs passes an order adjourning tomorrow's matter or passing a formal order the court is not willing naturally
লাস্ট টাইমে ওরা তাই বলেছিল যে আমরা ইয়ে করব
Didi 3624 কালকেও করেছিলেন স্যার কালকে
নয়নবাবু ডাকুন
একটা তো 14 তারিখে হয়েছে হ্যাঁ 14 তারিখে হয়ে জজ সাহেব
it was taken by your lordship on 14th August and kept for yesterday yesterday there was original side day but Mr. Datta has mentioned tried to mention also yesterday suit filed by the opposite party
It has been served upon the learned counsel
They appeared
representing
also.
the opposite parties. All are being represented.
Yes, yes. Even today's my lord fixing has also been served.
That it will be taken up at 2 p.m.
My lord can see.
No. When it is being mentioned from the bar, it is deemed to be sacrosanct.
Oblige.
What is the suit?
Suit was for Millard specific performance of an unregistered, unstamped document. When Millard they tried to move the matter ex parte.
In respect of a flat or
in respect of a house.
In respect of a house.
Residential building. When Millard they tried to move the matter ex parte, the injunction was refused on the ground by the same court, stating that 30 years of delay has not been explained properly. So the delay is unexplainable. So no injunction. Millard immediately
read by you.
Read by the opposite party.
Opposite party.
Opposite party is the plaintiff. I am the defendant. Petitioner before the lordship.
Defendant is the
Millard, the person who is saying that Millard he is the Millard on the basis of that order on the basis of the unregistered, unstamped document. He is seeking specific performance of Millard the sale agreement.
So the plaintiff had sought for.
The plaintiff has sought for specific performance.
The plaintiff has sought for specific performance
of that unregistered, unstamped deed.
He is the opposite party here.
The opposite party.
Your status.
I am for the Millard, the owner, legal heirs of the owner against whom he is claiming.
That.
Yes, I'm sorry. Now, Millard, they tried to move the matter ex parte when the suit was filed in 2017. Specifically, Millard, the injunction was refused by the court, stating that, Millard, I'll take Millard to the said order, stating that no delay of 30 years, Millard, 87, the deed was of the purported deeds of 87. They tried to file the suit in 2017, tried to move an injunction in 2017. The injunction was refused.
Deed means agreement.
The agreement, yes.
The agreement,
the agreement, yes. 1987.
1987.
And now, Millard, they tried to move.
And the specific suit was
2017.
1 minute.
Now, my lord, kindly come to page 1031. 103. My lord will get Millard order dated 12th of Millard December 2021.
1 minute.
14th of 2021.
Agreement dated
Millard 2/2/1986. Sorry, 1986. That my lord will find at page 42.
2/2/1986. Unregistered.
Unregistered, unstamped.
Unstamped.
Of a residential property and at Palm Avenue. Moore Avenue. Now, Millard kindly comes to 103.
1 minute. Title suit of 267 of 2017. So after 14 or
86
16, 30 years, after 30 years.
Now, Millard, on contest, the injunction was Millard contested between the parties. Kindly see the first order of injunction, which Millard, the order 13 will run to final hearing.
The impugned order is?
Impugned order is Millard. I'll show to impugned order. Impugned order is of Millard 12/8/2025, but I'll come to it later. But first, kindly see Millard 103.
Yes.
I will not bother Millard, your lordship Millard, on the entire
In
order.
respect of temporary injunction petition.
Yes.
On contest.
On contest. Kindly comes to 105. The ordered portion. Kindly comes to last penalty, second paragraph. In this specific case, the plaintiff pleaded that she is in possession of the suit property. So the plaintiff is in better position to make a prayer for specific performance. The plaintiff entered into an agreement in 1986. In the injunction petition, there is no explanation as regards the cause of delay caused in filing the suit after 30 years. Kindly mark. The prayer of the plaintiff is at face time barred and barred by limitation. After the facts, I have no hesitation to hold that the plaintiff failed to prove a prima facie case of balance of convenience in her favor. Moreover, the loss is not irreparable. Such and such, Millard dismissed. Now, Millard, kindly see, immediately, I file a order 7 rule 11 on this issue. Same. Kindly comes to page 51. Kindly comes to page
1 minute,
51.
1 minute. Page 51. When it comes to let a Xerox copy of the notice be
Yes,
ready.
I'll put it. এটা একটু xerox করতে হবে। Originalটা আপনার রেকর্ডে রেখে দিন just xerox. Kindly comes to 51.
The original should be in the record.
Yes.
Should be, not maybe.
Should be.
Should be.
Now, my lord, kindly see
51.
51. Kindly takes page 52. Millet, I filed an application under Order 7, Rule 11 on the ground of same Millet limitation. Kindly comes to Millet to Millet, take your lordship to the point taken. Page 81, part of Millet Order 7, Rule 11.
Page 81.
81, because Millet, I had filed Millet taking additional points of the limitation, a supplementary affidavit to Order 7, Rule 11. Kindly comes to page 81. Kindly see page 82. 82, somewhere around the middle portion of the page, kindly see law of limitation is marked, underlined.
Privacy barred by the law of
Yes,
limitation.
limitation, and there is no explanation. Same language, the learned judge has refused the interim order. Delay for filing the suit after 30 years as on date of the passing of the said order. Consequently, it was held by the learned court there was no prima facie case for granting an interim injunction by the plaintiff, nor the balance of convenience and inconvenience was in her favor, and therefore the question of suffering any loss and injury did not arise with the said observation. The said injunction application was disposed of and dismissed on contest with a clear observation with regard to the findings, facts that reflected therein, even though the original order is lying in the court. So, Millard, Millard, by way of supplementary, I brought that order into record, passed by the same court, that you have rejected, the learned judge had rejected the injunction on the same only a point that delay of 30 years has not been
explained.
Yes. Now, Millard kindly comes to the impugned order. At the last end, Millard. Where on contest, kindly takes Millard page 4.
Yes.
Page 4, last para, coming to the case in hand. Coming to the case in hand, it appears and from the averments made in the plaint and the plaintiff has filed the present suit for specific performance of contract, declaration, recovery of possession, and confirmation of possession. The plaintiff, para 37 of the plaint, has pleaded that the cause of action of the suit arose on 15/8/2016, lastly on 27/2/2017, and the present suit has been filed on 14/3/2017. As per awareness made in the plaint, there is hardly any scope to say that the plaint does not disclose any cause of action. The question of limitation on the ground which defendant number 3 and 4 have pleaded for rejection of the plaint is a mixed question of facts and law, and the same is required to be established by adducing cogent evidence at time of trial. This court is of the view that rejecting the claim at the threshold despite clever averment made in the plaint cannot be summarily decided as semi-legally unstandard considering modus and diligence. I mean, this is contrary to the same court's observation. The same observations were there when injunction was moved on contest. And it is apparent, Millard, that there is no explanation of 30 years delay. And writing that after 30 years I come to know that you will not sell the property to me, will not save limitation. 86 Millard document, unregistered, unstamped, of a house in South Kolkata. In the plain, nothing written. Straight away suit, 2021 injunction dismissed on the ground that delay.
Whether Order 7, Rule 11 will lie.
Yes, Millard, Order 7, Rule 11 will lie, barred by law, limitation. Yes. D. Barred by law.
Barred by law herein,
Barred by
other,
limitation. Clearly barred by
other
limitation.
interpretation, not,
No.
that will be, whether it is,
Milad, I have Milad,
it
Supreme
will
Court
be,
is clear. Milad, if somebody tries to camouflage by drafting, while in Order 7, Rule 11, court can go into the Milad, the issue and see that whether there is a Milad clever drafting or not. It settles from 1977. Milad, I am carrying the judgments to show before your lordship.
Learned Counsel, yes. It is fact that after 30 years they have come up. It is fact. It is also fact that whether it is barred by limitation or not, that will have to be decided,
Milad, if
not at
Milad
the
in
stage of
Milad in
Order
that
7, Rule 11.
Milad in
Council.
that, then otherwise Milad, the order passed by the which has attained finality, the order which has been Milad, the
Yes,
injunction which was dismissed,
the Learned Court was pleased not to pass any order of
only on the
injunction.
ground that
Only
Milad,
on the
there is
ground,
no
yes.
no explanation.
That is a separate aspect as regards to granting injunction, and
Absolutely,
now as
absolutely.
regards to Order 7, Rule 11.
Absolutely. Milad,
Both are not,
absolutely.
do
I
not
bow
mix
down.
up.
I bow down to your lordship. Milad, when Milad, kindly see, Milad, when the same court has held that I am rejecting your injunction because there is no, the court, kindly see what's the observation of the court that has reached finality. Kindly see Milad, page 105. Once for Milad, kindly Milad had already seen. Kindly see for once again 105. Already held. Kindly see.
In the specific case, the plaintiff,
In the injunction, there is no explanation. The plaintiff on the face of it is time barred and barred by limitation. This is not challenged. This is binding. Not only that refusal, the court says that it's barred by limitation.
now what is in the yesterday, tomorrow, what is it is fixed
Milad,
on?
the here, Milad, the witness action, chief tendering and witness action. Now, Milad, if Milad, it is pending before your lordship, Milad, I'm seeking a stay of this order because it's contrary to the observation. It's not only said that simply said that at this stage, and what Milad is saying that would be in the case that for Order 30 and Rule 2 is separate and Milad injunction is separate. Milad, for Order 7, I bow down. But the court,
IFSC, barred by law.
Milad, there is already a declaration by the court, observation.
It might have been written. That might have been written there, but
not challenged.
Not
reached finality.
After all, in while considering Order 7, Rule 11.
But my lord will kindly see, 1977, Milad, the camouflage drafting. Milad, what are you submitting, Milad? I am trying to make very well. Milad, for tomorrow.
Yes.
For tomorrow.
Come to that stance.
Yes. For
that
tomorrow.
Until and unless a revisional application is not disposed of, let
the court stay his hands for tomorrow. In the future, Milad, let us will give another notice and again come back before your lordship. We are not going away finally.
But prima facie, the court is of the view that
tomorrow,
that point won't be considered at the time of Order 7, Rule 11. As regards to the impugned order, the court is not.
Very well. Milad, what I bow down, Milad, for tomorrow, kindly stays, Milad, the hearing. We'll come back to your lordship. Again, we'll give notice and come back to your lordship. That matter is pending before your lordship. My lord is already in season of the matter.
See that until unless this revisional application is disposed of.
Kindly, Milad. So to avoid any kind of controversy.
But
because this will give rise to another order, another challenge.
1 minute. It will be fixed on.
Very well.
Today's 20th.
20th.
25th. It will be fixed. 25th of August. In the meantime, you serve notice upon the Learned Counsel representing the opposite parties that the matter will be fixed on, matter will be taken up on 25th. 25th. দেখুন তো টপিক কিছু আছে?
Can I pay for 31st Monday, next Monday?
31st.
Yes. Because it will require some time, Mr. Lodge. Till such time, I will stay the order, stay the proceeding.
I think, Learned Counsel, it is being stayed till 31st. Let the matter appear on,
Yes, I'll pray for you. If my
let the matter appear on either 25th or 27th.
31st, my lord, we can come back on 31st and pray for, if my lord, it seeks more time, we can pray for extension. My lord, may I file the affidavit of service, my lord, of the first notice, and I'll make a copy of that.
Copy of
second
that
notice,
also.
both.
Actually,
This is the first mentioning notice, that's the second one.
ওরা যে ম্যাটারটা দুটোর সময় হিয়ারিং হবে সেইটা ওনারা নোটিফাই করেছেন, সেইটার একটা ফটোকপি দেবেন,
আমি
সেইটাও
দিয়ে
রেখে
যাবো।
দেবেন, ঠিক আছে?
হ্যাঁ, জেরক্স করতে।
The আচ্ছা, affidavit of service. Learned Counsel, this is affidavit of service.
Service of the mentioning notice, first one. First.
Affidavit of service in respect of the mentioning at the first time, at the first time has been filed. Let it be kept to the record. Full stop. The Learned Counsel also files along with that a photocopy of the notice notifying the Learned Counsel representing the opposite parties, intimating that the matter will be taken up at 2 p.m. today. That is date দিয়ে দিন 20th of August 2026. Full stop. Paragraph. In spite of the said notice, paragraph, in spite of the said notice, none is representing the opposite parties. Full stop. Paragraph. The next paragraph. The Learned Counsel representing the petitioners submits that in respect of an unregistered and unstamped agreement for sale in respect of the suit property, which is of the year
92 to 1986.
Dated 2/2/1986. In respect of বলেছি, starting করেছি in respect of, হ্যাঁ ঠিক আছে the opposite parties plaintiffs, continuation, the opposite parties plaintiffs have sought for specific performance of the said agreement through the title suit being number 267 of 2017, pending before the Civil Judge, Senior Division, 3rd Court, Alipur. Full stop. The Learned Counsel further submits that at the time of passing the temporary, the order of temporary injunction, which the Learned Court was pleased to reject, had opined that in the injunction petition there is no explanation as regards to the cause of delay caused in filing the suit after 30 years, and further submits that in spite of such observation at the time of passing the temporary injunction application, the Learned Trial Court, while disposing of the application filed by the petitioners, defendants, seeking rejection of the plaint by filing an application under Order 7, Rule 11, the self-same Learned Trial Court has been pleased to reject the prayer under Order 7, Rule 11,
same issue of limitation.
full stop. Being aggrieved by and dissatisfied with the impugned order of rejection of the application under Order 7 Rule 11, the petitioners have preferred the present revisional application, and the present revisional application, in spite of being not disposed of, the learned trial court has fixed tomorrow, that is 21st of August 2026, for evidence of the on behalf of the plaintiffs. Full stop. In such situation, the learned counsel seeks a stay of the evidence. Full stop. Paragraph. Consider the submission of the learned counsel. It is fact that the revisional application has been preferred, being aggrieved by the order of rejection of the prayer for rejection of the plaint, under Order 7 Rule 11. By the order of rejection of the prayer, seeking rejection of the plaint. দেখি সেন্টেন্সটা আরো পড়ুন লাস্টের সেন্টেন্সটা পড়ুন। As such, until and unless the present revisional application is disposed of, this court is of the view that the trial court লাস্টে কি বলো, লাস্ট সেন্টেন্স কি বলো? না, এটা কাটুন। In such situation, let the evidence on behalf of the plaintiffs in such situation, let the proceeding before the trial court be stayed till 31st of August.
Mr. Shonak Bhattacharya is appearing on behalf of opposite party number 1, Your Lordship. Engaged in courtroom number 37.
You are representing opposite party number 1?
Party number 1. I'm led by Mr. Shonak Bhattacharya.
Achha. Learned counsel, where were you?
Engaged in courtroom number 37, Your Lordship.
Tomorrow it is fixed for evidence of the witness on behalf of the plaintiffs. It is being stayed till 31st of August. At least somebody should have been there.
I understand, Your Lordship. All were engaged in other courts.
তাহলে ওই যেখানে none is representing ওটা বাদ দিন, ওই যে none is representing the opposite parties, দেখুন এক জায়গায় বলা আছে সেকেন্ড প্যারাগ্রাফে। ওই যে ওখানে বললাম না, ফটোকপি অফ দি, হ্যাঁ, that the matter will be taken up at 2 PM today, that is তারিখ এত, তারপরেই বলেছে, হ্যাঁ এর দিয়েছেন তো, হ্যাঁ the opposite, ওইখানে লিখুন the opposite party number 1, namely
Parul Shashmal.
Srimati Parul Shashmal is being represented. ঠিক আছে, is being represented. এবার যা যা হলো ঠিক আছে, লাস্টে চলে যান। Let the proceeding before the trial court, let the proceeding of title suit number 267 of 2017 7 of 2017 be stayed till pending before the trial court, যে trial court আছে, be stayed till 31st of August 2026, full stop. Let the matter appear on 31st of August 2026 for here under the heading contested application. 31st of August. When Mr. Bhattacharya is here, learned counsel, until unless this one is disposed of, the proceeding should not. That one is against you. This one, as regards to that one, until unless the 7-1 application is disposed of herein. Revision application is,
yes.
that should be state. That is not the order today, but future I am saying. But as regards to their prayer under Order 7, Rule 11, this court is of not the same view of that of the revisionist.
Very well, we will have
come.
kindly hear
On
it out on
31st.
31st. Very good.
31st.
Lovely.
And next. Even serially.
Number 24.
I appear for the petitioner in this. My lord, item number 24 and 56, my lord, are arising out of the same suit.
Same suit.
My lord, my lord,
Different orders.
yes, my lord, that is the issue, my lord. The respondent in that, my lord, in this application is
the petitioner
the
there.
petitioner there. My lord, we have filed a letter, my lord, we have sent a letter to ask for a copy of that, my lord. He has not replied. My lord, if my lord direct service in that, and my lord tags the same together for hearing next week, my lord.
Item number 24. 24 is Gyanendra announcing alias JK, and item number 60.
56, my lord.
56.
If the order may be uploaded by the evening, you can produce the code below tomorrow.
We have heard it. It will be uploaded.
No, nowadays court, because of us must be. Court doesn't believe usually saying that. Because of there must be some predicament on our side, we must have done something. That's all. No, that's all. That will do. We'll search in the server by night. No, that will be okay. Obliged. To avoid any embarrassing tomorrow for Mr. Dotto tomorrow, if we can produce the order. No, that my lord is saying that's enough. They are not representing down. The advocate set is different there. Obliged.
Yes, my lord. Yes, my lord. Yes, my lord. That is the issue, my lord. Without knowing my lord, without having a look at the brief, my lord, it's not possible to say. My lord, this is, my lord, with regard to a, my lord, rejection, my lord, a refusal to accept written statement after the period had passed, my lord. Yes, my lord. The issue in this, my lord, is that, my lord, the written statement was filed, my lord, in 2024. My lord, the suit is from 2022. My lord, the date of the summons, my lord, I have to see once more, my lord. The issue that had arisen, my lord, is that the plaintiff the original plaintiff, my lord, had passed away in 2022 itself and had been substituted only in 2024. Yes, my lord. My lord, yes, my lord. The original plaintiff, my lord, passed away in October 2022 and was substituted in January 2024. And only after that, my lord, with this application for filing of the written statement, my lord, this application was filed by the defendant, my lord, the petitioner in this. Yes, my lord. Now, this is arising out of that. Yes, my lord. My lord, that I'm not aware of, my lord. The brief is not with me, my lord. my lord petitioner. Number 36 of 2022. Four, 56. My lord, if my lord directs service of the second division. No, my lord. My lord, I shall serve again, my lord. Affidavit of service is not ready. Very well. My lord, on the other revision, my lord, is also to be served upon my lord the petitioner. My lord, that is, my lord, not been directed. Very well, my lord, I shall attempt that. Grateful. I shall do. Grateful. Grateful. I shall serve notice, my lord. Grateful, my lord. Grateful, my lord.
Number 25.
Yes. My lord, I am for
Aviator
the
officer.
petitioner here. I am paying for a not today, my lord, because my senior is engaged in court number 37 presently. If your honor kindly fixes the matter tomorrow, it will be highly obliged. Yes. We have preferred. Sir, the plaintiffs, that is the opposite parties, they preferred an eviction suit, ejectment suit, before the Alipur court, and yes, I am a tenant, and they preferred an application under Order 6 Rule 17, and thereby the amendment application. Yes, that has been allowed. They have prayed that there were two plaintiffs, and they prayed that they have got their possession. Yes, there was a partition deed between them, and their title remained changed, but their title changed.
The other has to be transposed in the category of defendant.
But our bone of contention was that they preferred the transposition under Order 6, Rule 17, which we were opposed by filing written objection there. And if Your Honor kindly.
My lord will kindly come to the schedule.
No, sir.
Lordship, at page 32 kindly comes to the schedule, Lordship, of proposed amendment. So Lordship has got it. So Lordship, the A was Lordship transposing plaintiff number 2 in the category of pro forma default, and the rest Lordship regarding the changes, that what happened during after the suit was filed, during pendency of the suit.
Yes, my lord, if my lord comes to the prayer position, they have asked that thereby allowing the instant amendment application filed by the plaintiff, permitting them to amend the pleadings in terms of the proposed amendment. I am saying that Order 1 deals with the parties to the suit and Order 6 deals with the pleadings. And if they file an Order 6 Rule 7 application, that should go to the pleading. Yes, Order 6 Rule 17 application, that should go to the pleadings, and they have sought that the plaintiff should be transposed, plaintiff number 2 should be transposed as a defendant. And we also filed our written objection, and thereby we categorically, yes.
Yes, my lord.
My lord, no, there has been no change. No. Yes, I am a tenant under them. The he is my admitted landlord. Yes. He will be plaintiff number 1. Yes. Yes. 2 has been sought to be transposed. No, my lord, I am saying that had there been, it is a settled position.
Original side also.
কি বলে সোমবার দেখুন তো
মানডে তো কোনো কিছু
সোমবার টপে আছে কিছু
না, এটা আগে করব।
দুটো পার্ট আছে, দুটো পার্ট হার্টের পরে রাখুন, দুটো পার্ট হার্ট তারপরে ওইটা তিন নম্বর থাক এটা। It will appear after the part heard matters on Monday.
Okay, my lord.
Learned counsel allowed the Order 6 Rule 17. Come prepared.
Yes.
There is nothing on your behalf.
Great.
If you had been the advocate on record, the matter could have been disposed of. You are not the advocate on record?
No, my lord.
Sure.
Yes, our senior chamber senior is there. I mean,
Next.
Twenty-six.
My application, my lord. Landlord is the petitioner. Is the petitioner before my. A suit for a.
You are
Landlord.
eviction.
Suit for eviction.
You are for the
Landlord. Landlord is the petitioner. Suit under the West Bengal Premises Tenancy Act.
1997.
And
section, which section?
Default
6 or 2G? 6. Under which ground?
Defaulter and reasonable requirement.
Reasonable requirement.
Suit instituted in the year 2005. Suit was going fixed for peremptory hearing. A day's adjournment was paid for or at the time of preliminary hearing, since the plaintiff's distant relative had expired, he has to leave for Nagpur. That adjournment was turned down and the suit got dismissed. Thereafter, a miss case was
Probably prior to that, several adjournments were sought
one
for.
or more.
Have you produced the entire order sheet?
Entire order sheets are there. If my lord takes up the order at page 27.
Page 27.
Page 27.
So,
And the relevant portion is at page 29.
the impugned order is of dismissal.
Not dismissal. Not dismissal. The miss case was registered immediately after dismissal. Page 29 is the order wherein the suit is dismissed. The suit was dismissed.
Which is the impugned order?
The impugned order is at the last page, wherein the suit
Order
was
124.
124. There's the orders, the impugned orders are at pages, are orders dated, order number 120, order number.
So after dismissal of the suit for ejectment, you had filed
a miss case. Order 9, Rule 9.
Order 9, Rule 9.
Evidence was adduced. The tickets were marked as exhibits. There a prescription was given, was marked also. Since the plaintiff was suffering from a tooth problem, a dentist's prescription was marked.
No, the adjournment was sought for on the ground that
there was a death in the family.
Death in
And
the family, as
also
such,
on
you had
other
to
ground
go
that
abroad.
he was suffering from a teeth problem. He had to go for operation. The two occasions the adjournment was for, 2 grounds. Suit got dismissed.
Two grounds or 2 occasions?
Two grounds.
Two grounds on the same day.
Same date. When the suit got dismissed, Order 9, Rule 13 was filed immediately on 19th of December 2022. The suit.
Order 9, Rule 9.
Order 9, sorry, my lord. Order 9, Rule 9 was filed on 19th December 2022. It was fixed that service could not be effected since the original defendant expired. Substituted defendants were served. They were not appearing. Order 5, Rule 20 application was filed. Substituted service was allowed. Everything was. The documents which were marked for exhibit was one of the doctor's prescription. Now the dentist, who is a busy doctor resides in Cosba, has his chamber in Cosba, is being called for adducing evidence. My lord, everything is on record. My lord, that doctor is not coming.
Have you annexed the doctor's certificate or that
My lord, if my lord turns the order number 121 dated 11th of May, 11th of April 2025.
Have you annexed the photocopy of that
The
prescription?
doctor's certificate, it is recorded in the order. If my lord, no, that has not been annexed. That has not been annexed.
The thing which I intend to see, that will reveal from the certificate. Do you have you produced?
No,
annexed the
not
photocopy?
not annexed. If my lord grants a liberty to file a supplementary within 2 days, I can file it. But if my lord, the doctor's prescription medical certificate of Dr. Supreme Mukherjee is marked, if it is recorded in the order, my lord, order number 120, the impugned order.
120.
Order number 121, dated 11th of April 2025. The document, the prayer is allowed during the examination in chief PW1. The following documents are exhibited. Letter of authorization, signature of PW1 on medical certificate exhibit. Apart from the above documents, the following documents are marked for identification. Photocopies of the tickets of the flight, original prescription of Dr. Supreme Mukherjee X1 for identification, medical certificate of Dr. Supreme Mukherjee X2, CT scan report X3 for identification. These are the documents which were marked for identification. Now the court is asking the doctor to be present in court before the dock, in the dock. But a busy doctor, is not possible for him to leave the chamber and come to. It's a suit for eviction which is pending from 2005. Suit dismissed on 2022. More than 17 years have passed, and now it is 2026, end of 2026. Suit instituted on the ground of reasonable requirement and default is pending since 2005. It's unheard of, my lord. And the court is saying that until and unless you bring the doctor, and the miss case would be dismissed. All right. If this be the situation, it's on record, everything is there, the air tickets is there.
So the impugned order is?
The impugned order starts from order number 120 to 123. 124, my lord.
How many orders have you challenged?
My lord, these are the continuous orders of the miss case where evidence is being, the marks. 4 orders. If my lord requires the subsequent orders after 7th of December, 7th of January 2026, and produce the orders also, my lord. If this be the situation, everything is the restoration application on the valid ground that he has to leave for Nagpur. Air tickets were also annexed, were marked as exhibits. My lord, this, my lord, unfortunate landlord there, landlady. It would be an unfortunate landlady there. If the suit again has to file and institute a fresh suit.
First of all, learned counsel, you will have to produce the photocopy of the prescription and
The medical certificate.
Those which have been marked
as exhibit.
X for identification.
Yes, my lord.
The photocopies of the original prescription and the medical certificate. These two are to be provided through supplementary
By
affidavit.
supplementary. And next date is 28th, my lord. If my lord.
And in the meantime, you serve upon the adversary.
On the opposite party. And if my lord makes an observation, if the adjournment is sought for on that day, next day before the trial court should consider the prayer for adjournment. My lord, until and unless the doctor does not come out or interference of the High Court is there, my lord, the entire proceedings from 2005 would be infructuous then. If
Produce this order only, that will be sufficient. That will suffice. There won't be any stay or in the any order in the sort of stay.
I'm grateful. I'm grateful. That would suffice.
Admitted, but that's enough. That will suffice. The learned counsel representing the petitioner or petitioners?
Petitioner. Landlady is the petitioner.
Petitioner landlady submits that in this case, under Order 9, Rule 9.
Rule 9.
The original prescription and the medical certificate issued by the doctor not been believed by the learned trial court. On the contrary, the learned trial court has directed the doctor to be present
in the dock
and to adduce evidence. Challenging the same, the present revisional application has been filed. Full stop. On perusal of the record, it transpires that that photocopy of neither the original prescription, the photocopy, neither the photocopy of the original prescription nor the photocopy of the medical certificate of the said doctor has been annexed. In such circumstance, in such situation, the learned counsel is requested to annex a photocopy of the same. Full stop. Paragraph. In the meantime, through supplementary affidavit, liberty is granted. Liberty. In the meantime, liberty is granted to the learned counsel representing the petitioner to produce দুটো documents. ঠিক আছে, এবার হচ্ছে in the meantime the opposite party be served with the revisional application. So until and unless you file the supplementary, you won't be able to revisional application. Full stop. Let the matter appear.
Any convenient date, my lord.
Look, you will be able to.
Will you be able
to provide the supplementary affidavit
within 2 days?
Full stop.
Today we are on 24th. Today we are on 20th, my lord.
At this stage, the learned counsel submits that he will be able to produce the photocopy of the medical certificate আর আরেকটা কি যেন ছিল prescription কি যেটা ছিল certificate and prescription within 24th of August Let the matter appear on 25th of August. 25th. Full stop. ঠিক আছে? Thereafter, you will have to serve. Let the matter appear on 25th.
And there may be an observation since the matter is pending before the trial court. And not praying for any stay, my lord. The court should grant an adjournment, my lord. My lord, that would be a difficult.
This order will suffice.
May I be permitted to interject once? But the matter which was taken up in the morning, I mentioned it before court number 2. The court number 2 has been pleased to matter will be kept tomorrow in the to be mentioned. He will express his mind that I'll be releasing the matter so that matter can be taken up by this court. I've mentioned there, the matter will be released.
So
I just inform because see, the files will be called for by this court. By that time, file has also been called for by court number 2.
As per today's order, it won't be called for.
Well, it will be released tomorrow. Grateful. That's. Sorry to interject.
Item number 27.
The 27 I beg to appear for the appellant, plaintiff appellant, appeal ready for hearing. But I, with the consent of my learned.
There's one application, CAN 1 of 2010, that is order 41, rule 27.
Probably stay application because
the application has already been disposed of.
I have to check it up, my lord. It's the previous number is CAN 8544
Old number is CAN 9639.
But I have to check up the record.
9639 of 2010.
It's probably an application for condonation of
either
huh? There was a delay, an application for condonation of delay which was condoned. Thereafter, the appeal was admitted.
It has been admitted.
Yes,
Now it is essay.
That is the thing.
Probably it will be either under order 41 rule 27 or stay.
But I have to check it up, my lord.
1 minute. Okay. আরেকটা ক্যান কোথায়?
কপি নেই, কোনো কপি নেই, আমি খুঁজেছি কোনো কপি নেই আমার কাছে।
9639, yes. Oh, application for stay of all further proceedings. Well,
now the appeal.
Let there be an order of stay in respect of.
It is a suit for declaration in true
till
sense, my lord.
Till the disposal of the present second appeal.
We are in possession.
Is there any interim order as regards to stay? That can be.
No, my lord, there was no formal order. Your lordship kindly comes to the judgment dated 1st of August 2014. 1st of August 2014, when the appeal was admitted for hearing and substantial question of laws has been framed, my lord.
At the time of admission.
At the time of admission. And at that point of time, my lord,
Yes,
directions
1/8/2014. What was the all respondent are given liberty to prepare file law court record at the junction with volunteers for
in true sense, it would be an application for injunction because we are in possession.
No, as regards to stay of all further proceedings, there is nothing mentioned there.
But it's probably we should.
No, there have no any mention. I gone through. And also 11/8.
Please, when the matter is being taken up for final disposal, let there be a stay till the disposal of the second appeal. And we are starting the hearing.
What I'm praying, my lord, with consent of my learned senior friend, my lord, date may be fixed next Tuesday, my lord. It's a very short matter, but
no.
very.
It is fixed for today only.
My lord, I
Yes.
understand. I
It is
understand.
it is being taken up today.
I understand, my lord. It's my lord. I am not. There are certain points of law, my lord, which I put taken care of, my lord.
The earlier order was 11th of August.
My lord.
In such circumstance, let the matter appear on 18th of August. Today is 20th of August. Let us start.
But only one thing, my lord, on that date, your lordships, I submitted before lordships that respondent number 2,
Hmm.
who has been expired. You have record this.
Respondent number 2 has expired.
Kindly see the 11th August.
Yes, so the learned counsel representative respondent 1 submits that the respondent number 2, Savitri Bala Ghosh,
My lord.
wife of Govindo Ghosh, has expired.
My lord.
Then I have to take steps, my lord, for substitution and other steps, my lord.
এটা আজকে out of list করে দেবেন তাহলে. Parties are not interested.
No, well, unnecessary.
If both of you are interested, that will appear in the list. Otherwise,
No. I am interested because I am suffering, my lord.
I have to take steps as my learned senior friend have pointed out, my lord.
That is a fact, not pointed out. That is
I
the
have
fact.
to take steps, my lord, because
this is order dated 11th of August.
My lord.
In the meantime, steps ought to have been taken. When will you be able to take steps?
My lord, by
if you provide the information as regard to legal errors, can you provide?
My lord, that is their responsibility also. If your lordships kindly directed me,
So,
I will serve.
Let it be between the parties.
I'll then you.
If you intend to have it disposed of
Course, my lord, because I am suffering.
Then you provide them with the necessary name and the address. How many legal heirs are there of respondent number 2?
3 legal heirs, my lord.
Provide the names and address.
My lord, by within a week we will take necessary steps.
When you will be able to provide the name of the legal heirs and the address of the legal heirs?
September. আজকে 20 তারিখ তো my lord,
by tomorrow.
No, my lord, 24. I will give that 24 as because I inform the other legal heirs, my lord. So I give the information on 24th August.
If you obtain the information
Within a week, my lord, we will, my lord, take all steps, my lord, required to be taken.
And only one correction there have also, my lord, in the order sheet expired in the year 2015, but in the order sheet it has been 2025, my lord.
Oh, expired on 3rd of June 2015.
15, my lord.
Acha. Not 2025.
No, my lord. 2015.
Setting aside abatement করতে হবে.
And also in the meantime, I have also one information, my lord, about the appellant. That one appellant has been expired. I have some one.
But I have to take instruction. My instructing advocate, he was there. A matter of his court.
And both the
instruction, it's so.
And both the application be filed within period, my lord.
It is up to you.
As because I am suffering.
I leave the matter up to you.
No,
both of you are interested, you can proceed.
I will give the instruction, my lord, about my legal heirs. But
you provide them. On perusal of the on perusal of the order dated 11th of August 2026, it transpires that the date of death of Savitri Bala Ghosh has been mentioned as 3rd of June 2025, 2025. ঠিক আছে? Instead, it should be 3rd of June 2015
My lord.
এটাকে না একটু বোল্ড করে দেবেন, ঠিক আছে? the 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 order dated 11th of August 2026 is modified to this extent, full stop, paragraph. The learned counsel representing the appellants submits that as per the earlier direction dated 11th of August 2026, the appellants have not been able to obtain the necessary particulars of the legal heirs till date, full stop. As such, the learned counsel seeks an extension of the time to file seeks extension of time to file the application for substitution, full stop. At the he further submits that an appellant, one of the appellants have also expired in the meantime, and in this regard also steps are required to be taken. Full stop. Consider the submission of learned counsels. Let the matter appear on 7th of September.
My lord.
7th of September.
Full lordship.
Deeply obliged. দিচ্ছি আমি।
Next.
Number 28.
28. Okay. Matter where
We were supposed to put in our written notes.
Yeah.
Willard, my learned friend was supposed to let me know Willard, the judgments he wants to rely upon so that I can deal with in my written notes. My written notes is otherwise ready, but Willard, I did not know the citation.
was not the case.
Huh?
The last occasion was directed that both have exchanged our notes on argument and presented it before your lordship.
If I deal with the judgment,
It is,
That applies to me as well. That
the
I am
authorities which both the sides intend to provide, that they
once he
provided.
gives me the citation, then only I can give my citation to him. But he was to argue first.
my notes on argument along with the authority that I have already.
Willard, kindly grant me a week's time that I'll put in my notes. Willard, I could not deal with Willard. Otherwise, it's Willard ready. What are these issues? Act.
No, এটা ঠিক আছে।
My lord, one more thing I need to clarify over here that last occasion a point was raised that whether that applicant has put his signature on the earlier wakalatnama in connection with that appeal. On my lord, that day also we checked and subsequently the record we have checked it. The person already signed that wakalatnama at that point.
All the more better for me.
I can show it to your lordship.
I take it Willard on face value. It's
Because my lord, we
even
took
better.
up the point that inadvertently he was left out. Then
Mhm,
my
mhm,
learned senior said that had it been
So now the position stands that in the wakalatnama he had filed,
there, but in the
but
name
But
of
he
in the
filed a separate appeal.
No, that was
but in the
my lord, may I comment one thing?
memo, but in the
My
memo.
learned senior can't take a to stand in two different courts. In that court, they are saying that suit is not maintainable. Over here, when I proposed on the very beginning that let that person be added as a party appellant in the appeal, then they said no, he have to prefer a second appeal.
But I'm scolded by my learned
No,
junior.
not
Willard, I'll
scolded,
put
my lord,
Willard
that was
everything
because my lord,
Willard in my notes.
that they are saying that they are appealing.
Let the court be clear, learned counsel. The present application means
four.
refers to
Can
Can
is
four.
addition of part.
I thought that this is another application in that
My lord,
regard.
that is notes on us. I notes on us.
It is mentioned the present application.
It's supposed to be can.
Nin. Blank the letter. as per the earlier, আচ্ছা ও হ্যাঁ লাগবে লাস্ট অর্ডারটা দেখি
তাই তো বুঝতে পারছি না।
Continuation of
At this stage, the learned councils submit that they will provide authorities in support of their contention.
they have already
Now, my lord, I
prepared the
got it. Now I got it.
They didn't, my lord, give it to me. They are
Neil,
So then, my lord,
No.
one line, let them submit an advance copy of that so that I also get
Acha
prepared
besh.
about
Very well.
to that extent, there won't be any order. To a smaller extent, it will be. কি বলেন, written notes of argument.
my lord, both.
Written notes of argument, annexing an authority being cited at 1994 volume 2 মানে 1994 টাকে ব্র্যাকেটে করবেন volume 2 SCC page 642 has been provided on behalf of the appellants.
The applicant.
Applicant.
They are wearing two hats, my lord, today.
Appellant also represented, my lord, word for the opposite party.
Applicant, full stop. A copy of the same has been provided today to the learned council representing the respondent number 1 and 2.
To all the respondents, to all the contesting respondents.
To all the contesting respondents.
Contesting respondents.
Full stop.
Contest
ঠিক আছে। Mr. Banerjee, learned senior counsel at this juncture seeks an accommodation for a week to counter the authority produced on behalf of the applicant accordingly
And to put in my notes, written notes.
and to provide written notes of argument. Full stop. In such situation, let the matter appear on when Mr. Banerjee? Next Thursday.
Subject to my lord's
27. Let the matter appear on 27.
Great.
আচ্ছা এটা কি বলে এনভেলপে থাকবে
That legal advance copy.
It's between
Advance
us.
copy,
You know,
advance
between us. But I will supply. Need
don't
not
think
worry.
that
Need
should
not
be
worry. Need
mentioned
not
here.
No hide and seek game before your lordship. You know?
Next.
Item number 29.
My lordship, I pray for not today.
Why? On which ground?
My lordship,
Each and every prayer should be on a ground. What is the ground?
my senior advocate is not prepared today.
You are the advocate on record?
No,
Who is the advocate on record?
my senior, Syed Samsul Arif.
He is the advocate on record. He is not ready. He is in court. Is he in court?
No,
Then provide your name only, not your senior's name. Provide your name only.
I am for the appellant, he is respondent. If pursuant to a direction of your lordships, I serve the notice upon the learned advocate as well.
Miscellaneous appeal.
Yes, my lord. As well as also respondent number 1 and 2.
1 minute.
Oh, sorry.
On the earlier occasions, the respondents were
Not present.
not being represented.
Yes, ma'am. That's why your lordships direct me to serve the notice.
Respondents. You are representing all the, there's only one respondent, na?
Two respondent. 1 and 2.
Apu Bibi and no.
Alia Begum and Sheikh Raju.
Saliha Begum and Sheikh
Raju.
Who is the appellant? You are for the appellant?
Yes, yes.
The respondent number 1 is
Saliha Begum.
Saliha Begum.
Yes.
Thereafter?
Sheikh Raju. Respondent
No,
number 2.
In bracket, what you have mentioned?
Opu Bibi. Yes. That is in the plain, that's why that name was the nickname probably.
So, alias Apu Bibi.
Yes.
Daughter of late Sheikh Sadek.
Sheikh Sadek.
And Sheikh Raju is son of Sheikh Anath.
Sheikh Anath.
When can the matter be taken up?
My lordship, next week.
Finally fix any.
Which date? Which date?
My lordship, Monday.
My lord, Monday and Tuesday, Mr. Tanmoy Mukherjee leading me, my lord, he is not available. That's why any day thereafter.
Let the date come from the bar.
No, my lord.
Which date? Which date? Because on that day there won't be any adjournment. Because on the earlier occasion, because of you, 1-page order was made, and because of the learned counsel
Yes, my
representing the respondent, kindly interchange. Today, 1-page order is being made.
Yes, my lord.
That should not be on the next day. On which date it shall be taken up?
আচ্ছা পেপার বুক আছে কি সেটা আগে ইয়ে করুন আমাকে বলেছিলেন পেপার বুক নেই মানে his senior informed me he is not carrying with the paper book, that's why he I also
আমাদের
xerox it one
আছে?
paper
আমাদের পেপার বুক আছে? হ্যাঁ নেই? ভালো করে দেখুন
I have prepared one set of xerox.
ওইরকম হার্ড কপি নয়, শুনুন ওই হার্ড বাইন্ড নয়, দেখুন তো ওখানে পেপার বুক বলে লেখা থাকবে, ওই হার্ড বাইন্ড হবে না।
আছে পেপার বুক আছে আছে
সামনের সপ্তাহ থেকে যেন এরকম না হয় বলে দিচ্ছি কিন্তু। ঠিক আছে, আছে ছেড়ে দিন। ওগুলো কোনো রিজন নয়, নিন। When to be taken up?
My lord, I have handed over him a set of the paper book, but because my lord from the bar I am submitting, his senior informed me he is not received the paper book from the department. That's why I am supplying him for proper hearing of that date, my lord. Otherwise he submit that.
He required that to be noted?
Yes, my lord, yes.
Won't be.
All right, my lord. First September.
Be kind enough to hand over.
Yes, here and now I am.
Be kind enough to inform your learned senior that the matter will be taken up on which date?
1st September.
Huh?
1st September.
1st September.
Yes. That affidavit of service kept.
The affidavit of service has been filed. Let it be kept to the record. Full stop. You are appearing on behalf of the appellant.
Yes, my lord.
You can comments today. She will take note of.
My lord, Mr. Tanmoy Mukherjee leading me, my lord. That's why, my lord, I am fixing it. Yes.
On consent of both sides, both the learned counsel, both the learned counsels representing the appellant and the respondent seeks an accommodation for a week for 10 days. For 10 days. Full stop. On consent of both sides, let the matter appear on 1st of September 2026. But full stop, on that day, it is further mentioned that on that day, there won't be any adjournment provided on whatsoever ground. There won't be any adjournment provided on whatsoever ground. Both the sides will have to come prepared.
Yes.
Next.
My lord, I am the respondent. For all respondent, I am appearing. My lord, not this week, my lord. In this matter, Mr. Sumit Dato appearing, my lord.
Kindly take note of a submission.
My lord, today I was supposed to file a compilation, but lordship, we don't have the copy of the exhibits and the deposition. I even requested my learned friend to supply me a copy of the same. So, lordship, we could not prepare the compilation because, lordship, this is a second appeal, lordship. So the paper book only contains, lordship, the judgment and decrees of both the courts.
The court will go through the evidence and the.
But we don't have any copy also. I can start, my lord, but I don't have any copy of the deposition and the exhibits.
My lord, like tomorrow, tomorrow or Tuesday, Monday, I have the comment.
Learned counsel, you are for the
respondents. All respondent.
Yes, you are for the respondents. Let the appellant complete her submission.
Yes, my lord.
Learned counsel representing the appellant or appellants? Appellants conclude her submission, then you will get the opportunity. In the meantime, you take note of her submissions.
Or lordship, without the exhibits and the deposition, my lord.
Each and everything will be provided. A trial court record দিয়ে দিন আর ওই দিন আমাকে পেপার বুক দিন.
My lord, here what happened? The plaintiff, we are the plaintiffs, my lord. We filed a suit for declaration, partition, and injunction and separate possession.
Suit for partition and separate possession.
Yes. And lordship, the suit was initially, lordship, decreed. Challenging that, my lord.
হ্যাঁ, ট্রায়াল কোর্ট, ঠিক আছে, ট্রায়াল কোর্টের রেকর্ডটা যখন লাগবে ওনাদের তখন সেটা দিয়ে দেবেন, ঠিক আছে? দিন. Yes.
Now, lordship, in the written statement, lordship, the respondents took a specific plea that, lordship, we have not incorporated one Jew Thakur as a party. Accordingly, lordship, we filed an application for amendment of plaint, and which was allowed, and lordship, we implemented the Jew Thakur as a party. Thereafter, lordship, suit was decreed. Challenging that, lordship, the respondent filed an appeal.
কি হলো আপনাদের? কি হয়েছে? কি অসুবিধা কি হচ্ছে? ফাইলটা এখানে নিয়ে আসুন, ফাইলটা দয়া করে এখানে নিয়ে আসুন, দয়া করে এখানে নিয়ে আসুন, এখানে রাখুন। শুনুন, আমি বাংলায় বলে দিই, এখানে রাখুন, যখন ওনার সাক্ষী এভিডেন্স যখন লাগবে তখন ওনাকে দেবেন, ট্রায়াল কোর্টের ওই জায়গাটা মানে রেকর্ডটা, ঠিক আছে? preliminary decree was passed.
Yes.
As regards to preliminary decree, there was
They
no challenge.
preferred an appeal, Lordship.
Oh, they preferred an appeal
Yes.
against the preliminary decree.
Yes.
Acha.
Now, Lordship, what
How many,
happened?
is the genealogy required?
No, Lordship, there are, this matter has a checkered history, Lordship. What
Checkered
happened?
history.
Yes.
Acha.
Now, Lordship, what happened? The learned lower appellate court, the first appellate court, was pleased to remand back the matter again to the trial court. Now, challenging that,
On which ground?
Lordship, I have to go through the
Acha,
judgment. Challenging that, Lordship, we preferred a first miscellaneous appeal.
Acha.
But, Lordship, inadvertently, in the cost title of that first miscellaneous appeal, we did not include that Jiv Thakur.
Acha. Who was not included in the trial court at the initial?
Yes. Now, what happened, Lordship? That
Jiv Thakur does not want to stay with you all.
Thereafter, Lordship, ultimately, this first miscellaneous appeal was dismissed.
Dismissed.
And we again went back to the learned trial court.
Acha.
It was dismissed on the ground that some of the parties have died and the decree was passed against dead party. So it was again sent back to the trial court. Now what happened, Lordship? The trial court rejects my, dismisses my suit. Challenging that, I again preferred an appeal. Now the appellate court this time has rejected my appeal on the ground that Jiv Thakur is not implicated in the suit. So, Lordship, I have preferred the second appeal, and along with the second appeal, I have also filed an application for addition of party for adding Jiv Thakur.
Acha.
So now both the appeal along with the application is pending.
Till date, the share has not been finally settled.
No, because after remand, both the suit as well as the first appeal was dismissed, my lord.
Yes.
Now, Lordship will kindly come to the
This
paper.
one is not a big one, not big issue.
So if today your Lordship allows implement of Jiv Thakur, it can be again sent back for final adjudication. Because Lordship in the suit,
whether Jiv Thakur is required or not, that will have to be gone through.
Lordship will kindly see first the memorandum of appeal, Lordship, that is at page, the order, Lordship, where the second appeal was admitted, Lordship, that is at page 44.
Yes. The Court of Appeal below.
May I read it out for your Lordship? Whether the Court of Appeal below was justified in dismissing the suit and affirming the ultimate decision of the trial court on the premise that one of the parties have been left out in partition suit, when in fact such party was added by an order of the trial court, though not implemented in the memorandum of appeal filed before it. And the second, whether the suit for partition could be dismissed for non-inclusion of some of the joint properties, or the court ought to have allowed the party to amend the pleading and included all the joint properties, not only to avoid multiplicity of proceeding, but on the principle of ex judicial justice. So these are the 2 points based on which Lordship now kindly allows me to place the judgment of the lower appellate court. Since Lordship, this is a judgment of reversal, of affirmance, my lord. That is at page 21. The Lordship has got page 21. This appeal coming on for final hearing on such and such, and in presence of such and such. Lordship finally comes to the second paragraph. This is an appeal preferred against judgment and decree dated 28th of April 2017, pronounced by the learned Civil Judge Senior Division 3rd Court, Paschim Medipur, in title suit number 55 of 2006, valued at such and such. Appellants, plaintiff of title suit number such and such, renumbered as such and such, thereafter simply referred as to the appellants, instituted a suit praying for declaration, partition, and permanent injunction. The respondents, defendant in title suit number such and such, simply hereinafter simply referred to as respondent, contested the appeal.
This is Chakraborty from page 22, points.
Lordship. Points 1 and 2, decision with reasons. For the sake of brevity and convenience, both the points are taken up together for consideration. Perused all the materials lying in the case record of title suit number such and such, renumbered as such and such. As I have stated earlier, the appellants instituted this suit praying for declaration and partition. Most of the respondents contested the suit, submitting written statement and prayed for dismissal of the suit. Admittedly, page 23, my lord. Admittedly, the subject matter of the suit, hereinafter simply referred to as the suit property, originally belonged to one Harihar Das, who died leaving his only one son, Raghunath, who in turn was succeeded by his four sons, Prangobindo, Radhakanto, Radharaman, and Radhanath. Amongst them, Radhanath died without having any issue, leaving behind a wife, Saraswati Dashi.
Yes.
Up till the version of the parties are identical. Discord and disharmony raises its head thereafter. Appellants alleged that the Saraswati Dashi became absolute owner of the suit property by dint of amicable settlement. They asserted that the said Saraswati Dashi sold the suit property to Prangobindo, Radhakanto, and Radharaman by dint of the original Exhibit 3A. Since then, the purchasers were enjoying the undivided property. The appellants claim that they have inherited the undivided 1/3 of Prangobindo in the said property. Likewise, the remaining 2/3 share in the property devolved upon the respondents. Allegedly, the respondent number 8 to 12 obstructed the appellants from harvesting the paddy cultivated by them on 9th of December 1993. They disclosed that the suit property was gifted to the predecessor of the respondent number 1 to 4 and respondent number 5 by the said Saraswati Das. They also claim that they have purchased the suit property from respondent number 1 to 5, vide deed number such and such. Appellants inquired into the matter and came to know that the share of Saraswati Devi was recorded in the RS record of rights, suppressing execution of the original Exhibit 3A. Appellants allege that they have come to know about Exhibit H on 13th of December 1993. In such circumstances, instituting the suit, the appellants prayed for a decree declaring that the RS record of right in respect of the suit property as devoid of any basis and illegal, and also decree declaring that the Exhibit H is inoperative and not acted upon, along with the decree of partition and other relief. The respondent number 1, 3, 5, 9, 10, and 12 contested the suits, submitting their written statements. They claimed that Radhanath died prior to the commencement of the Hindu Succession Act and Saraswati Dashi enjoyed life interest in the suit property. The answering respondents clarified that the RSROR was prepared on the basis of a Shalishinama Exhibit A, which was held on 2nd of January 1956, corresponding to the 17th day of such and such. After that, the said Saraswati Dasi, being a co-sharer, executed Exhibit H in favor of the predecessor of respondent number 1 to 4 and respondent number 5. Apart from H, the said Saraswati Dashi also executed Exhibit number 1 and the original Exhibit K in favor of Sushila, widow of Radhakanto, and Prangobindo respectively. Said Saraswati Dashi also executed an Orpon Nama endowment deed in respect of land measuring 20 decimals of land comprised in plot number 229 in favor of Sri Sri Hori Jiu Thakur. Respondent asserted that the said Hori Jiu Thakur is a necessary party in the suit.
Herein we are not concerned as regards to the share. So when Radhanath expired, that is not the concern here at this present juncture.
But Lordship, this appeal was solely dismissed on the ground that I have not incorporated this Jiu Thakur. Sir, show Lordship.
So when did Radhanath expire?
Lordship, sometimes, Lordship, before the commencement of the Hindu Succession Act.
Sometimes cannot be said.
দেখ ওটাতে আমার একটা নোট করা
Is there any document to that effect?
Well, Lordship, I do not have the exhibits. Hard document.
চলে শুন ট্রায়াল কোর্টের রেকর্ডটা দিন যেখানে এক্সিবিট আছে ট্রায়াল কোর্টের রেকর্ড টিএস নাম্বার হবে বলুন বলুন In this one, Mr. Bakshi was to appear.
No, no. Perhaps, Lordship, it was not marked as exhibit because, Lordship, from the learned trial court's order, Lordship, I find the list of the exhibits that is at page 9. Lordship, kindly sees. The death certificate is not there. Page 9, my lord. একটু রাখুন আমি লিখছি না। And Lordship, on behalf of the plaintiff at page 8.
Page 8 only.
The deed of
on
gift.
behalf of the plaintiff, deed of gift, 2 LR information
Yes.
slips and a sale deed.
deed.
Exhibit 1 to 3.
Yes. And on behalf of the
Registered deed of family settlement.
Yes, Lordship.
17 rent receipts.
Yes.
2 LR records.
LR
2 LR records.
Arrest record, gift deed, order sheet.
Original sale deed.
Yes.
Deed of Ekrar Nama, a certified copy of LR record,
And
a
Nadabi.
certified copy of Nadabi deed.
Yes. কোথায় পড়ছিলাম আমি ভুলে গেলাম।
Let us proceed now.
Yes. Lordship, at page 24, I'm coming back. They allege that Saraswati Dashi never executed the original exhibit 3A. Neither she had any legal necessity to sell her property by dint of that document. The answering respondents added that respondent number 9, 11, and 12 have sold some of the properties to the other person who are possessing the suit property along with such parties. Such purchasers have also not been included in the suit. Learned trial judge dismissed the suit, hence this appeal. Now, before proceeding with the instant appeal, the checkered history of the case should be recounted for appreciation of all the relevant questions. The suit was disposed of earlier with a judgment dated 30th of June 2008 and decree dated 10th of July 2008. And the learned trial judge was pleased to decree the suit in favor of the appellants.
Mrs. Chakraborty,
Yes.
Prior to the execution of the Orpon Nama in favor of Sri Horijiv Thakur, was there the existence of Sri Horijiv Thakur prior to the Orpon Nama by Saraswati Dashi?
This Orpon Nama is also not an exhibit. There is one Ekrar Nama, but this is not it. That is also not there. Some of the respondents cherished appeal against the judgment which was registered as title appeal number 114 of 2008. The appeal was allowed on contest with a judgment dated such and such, and the suit was sent back on remand. Being thus remanded back to the trial court, tried the suit afresh and delivered the impugned judgment. Plain reading of such observation of the learned trial judge reveals that such observations can be broadly divided into 3 categories. Firstly, the learned trial judge has taken note of some of the procedural lacuna in the plain, such as non-joinder of necessary parties, exclusion of joint properties from the common hodgepodge of partition, and secondly, has inferred that on the basis of the subsequent conduct of Saraswati, the original of Exhibit 3A has not been acted upon. Thirdly, the appellant did not challenge Exhibit H on account of fraud. Since the second aspect comes first from the chronological point of view and the third aspect comes as intertwined with it, I shall deliberate upon the first two. Then the first aspect will be addressed. How could the erstwhile co-owners execute the deed of settlement after admitting the said Saraswati, a co-sharer of their joint properties, long after execution of the sale deed of 1940, if she had transferred all her shares in the joint property by way of sale deed of 1940? How could Saraswati execute the said Arponnama deed if she had no title in respect of the aforementioned suit plot? In spite of the direction of the learned appellate court to implead the concerned deity in the suit, the appellant did not complete it. It is a settled position of law that a deed of title executed by a Hindu woman having limited interest before promulgation of the Hindu Succession Act 1956 can be challenged by a reversioner of the estate, and that has to be done within a period of 12 years from the date of execution of the sale deed or within a period of 12 years from the date of death of that Hindu woman. It is equally true that if the beneficiaries of the said deed relinquish their right accruing from the sale deed and allows the transferor, that is the Hindu woman, to remain in possession of the properties transferred by her and exercise her absolute right over those properties after promulgation of the Hindu Succession Act 1956, then the earlier deed will have no effect in the eye of law. The erstwhile predecessors of the respective parties to the suit land has relinquished the right in respect of the properties as transferred in their favor by the said Saraswati Das by way of the sale deed dated 1940. Surprisingly enough, the plaintiffs are absolute silence in the evidence regarding the alleged execution of the deed of gift of 1967 through fraud. They have only challenged the legality and validity of the alleged deed of 1967. PW1 raised objection against the arrest record of the said Saraswati Das but did not get any order from the concerned authority in respect of such objection. Relinquished her right in respect of other properties in favor of respondent number 5, the predecessor of respondent number 1 to 4, the predecessor of the respondent number 6, and also in favor of the predecessor of the appellants, namely Pran Govinda Das. Saraswati Das has exercised her right in respect of the suit plot number 209 by bringing a Bhakchas case against the Bhakchashi in the year 1957 and got an order of eviction of the concerned Bhakchashi. It is the golden principle of law that a party pleading fraud has to specifically establish it through cogent evidence. On the other hand, the appellants advance the following grounds to the appeal which are the arc of pivotal importance. Such grounds are enumerated hereunder. No issue regarding the legality and validity of deed of 1940 has been decided. The learned trial judge ought to have held that there was a legal necessity for the sale executed by Saraswati Das now in 1940. The burden to inquire about the existence of legal necessity lay upon the transferee, and such decision is vital for deciding the validity of the deed of 1967. The learned trial judge ought to have held that the deed dated 16th of March 1940 was executed for legal necessity and the same had been acted upon and the title was duly passed thereby. After executing the sale deed dated such and such, Saraswati Devi had no right, title and possession in the suit property. No property has been transferred by dint of Nadavi deed. Saraswati Das sold the property to her reversionary of the estate, and as such it was not necessary to challenge the deed within 12 years of the death of Saraswati. The family settlement is baseless as it was settlement is baseless as it is unregistered.
In the paper, it is in the paperwork. It is mentioned as the family sentiment.
Baseless.
Sentiment.
Oh, yes, yes. The record of right is not a document of title. The respondents have not prayed for declaration of the sale deed of 1940 as void, illegal, and not acted upon. As there is no decree declaring the deed of 1940 as void or illegal, no title has accrued to the respondent. Now, cumulative reading of the observation of the learned trial judge and the grounds in appeal brings me to the question as to what is the import of the original Exhibit 3A in the circumstances. Essentially, it is the fulcrum around which all the questions revolve around. I cannot forget that the document has been assessed thrice by 3 different forums. It must be added minutely over and above everything else, it seems to be the order of the day. The averment of the respondent in respect of the execution of Exhibit 3A can be gathered from their pleadings is patently contradictory. On one hand, they have stated that Saraswati did not execute the same. On the other hand, they have stated that the vendees of such deeds struck an unconscionable bargain upon the said Saraswati Devi, taking advantage of our minority and apparent control over her. They claim that the vendor never intended to execute such instrument and that it was not executed for liquidating some legal necessity. So far as the question relating to the legal necessity is concerned, the answer is not far to look. The recital of Exhibit 3A clearly reveals that the executant of the original of it executed the same for meeting the legal necessities categorically mentioned therein. She has specified that the debts incurred by her deceased husband, loss of crops due to flood, and her dire need of wherewithal to sustain herself compelled her to execute such transfer. I wonder if these are not legal necessities for a widow who lost her husband early in her life when the term of the legal necessity entails. What the term of the legal necessity entails. In any case, the respondents did not produce anything to prove that such reasons as cited in Exhibit 3A are baseless. Goes without saying that the respondents have not produced anything to establish that Saraswati Das was minor at the time of executing the original Exhibit 3A. Naturally, the document cannot be questioned on that score. The respondents argued that the appellant have not proved the execution of the original 3A, producing the original deed itself. Undoubtedly, that the original deed has not been produced. Instead, the Exhibit 3A has been produced, which is of the nature of secondary evidence. The respondent stated that such documents does not prove that Saraswati Das actually executed the original of such document. However, in view of the admission regarding such execution of such deed mouthed by DW1 during the cross-examination, such criticism pales into insignificance. That being said, I am now confronted with the actual contention between the parties. What is the true import of the original 3A? Who are the rights of the parties? My quest for answers took me to the bulwark of mandates laid down in several precedents, recapitulation of which should be able to clear the confusion. The judgment reported in such and such, in the judgments reported in such and such, it was observed that the effects of Section 4.1.14.1
AIR 1957 Calcutta page
দেখ মেমোরান্ডামে দেখতে আছে কিনা মেমোরান্ডাম অফ অ্যাপিলটা No, Lordship, not mentioned. 1959 Supreme Court 577 and AIR 1961 Patna 6557. That's wrong. It was observed that
out of 60557, one should be with AIR 1957. It was observed that the effect of Section
4.1 and 14.1 of the Hindu Succession Act read together is that the Hindu law regarding the Hindu widow's estate will not apply to property held and possessed by the Hindu female from the date of commencement of the act, and such Hindu female shall hold the property thereafter not as a limited owner under the Hindu law but as a full owner. These provisions affect property held and possessed by a Hindu female at the date of commencement of the act and cannot affect any property which was held and possessed in the part of such female but which she had transferred and thereby ceased to hold and possess at the time of commencement of the act. Obviously, the proposition of law enumerated above is squarely applicable here. Saraswati Das, being a widowed Hindu woman in the year 1940, transferred her limited estate in the demised property for meeting legal necessity. That being the position, I ask myself whether she can avoid the effect of such alienation on the date of promulgation of the Hindu Succession Act merely because she is possessing the property which she has alienated. In this regard, I must remind that the respondents have sought to bank upon some records of right for establishing that Saraswati Das continued to possess the suit property even after execution of the original Exhibit 3A. Again, I fall back upon the precedents for answer. In such attempt, I stumbled upon a judgment reported in AIR 1966 Supreme Court 1879, wherein the Honorable Apex Court observed that the explanation to subsection 1 of 14 defines the word property as including both movable and immovable property acquired by a female Hindu by inheritance or device. Subsection 2 of 14 also refers to acquisition of property. Though the explanation has not given any exhaustive connotation of the word property, the word acquired used in explanation and also in subsection 2 of section 14 clearly indicates that the object of the section is to make a Hindu female a full owner of the property which she has already acquired or which she acquires after the enforcement of the act. It does not in any way confer a title on the female Hindu where she did not in fact possess any vestige of title. It follows therefore that the section cannot be interpreted so as to validate the illegal possession of a female Hindu, and it does not confer any title to a mere trespasser. In other words, the provisions of section 14(1) of the Act cannot be attached in case of a Hindu female who is in possession of the property of the last male holder on the date of commencement of the Act when she is only a trespasser without any right to property. Similar views was adopted in 1967 Supreme Court 1786. The question was further expounded in another precedent reported in AIR such and such, wherein it was held that in identical circumstances that she cannot be held to have acquired any right under the Hindu Succession Act, because before any property can be said to be possessed by a Hindu woman as provided under 14(1) of the Act, two things are necessary. One, she must have a right to the possession of that property, and B, she must be in possession of that property either actually and constructively. The matter came up for consideration yet again, and the Honorable Apex Court deliberated in the judgment reported in such and such that limited ownership is a sine qua non for applicability of sub enlarged by the operation of that subsection. Such view was approved yet again in another judgment reported in such and such. In view of the above proposition of law, it is crystal clear that Saraswati had no authority to transfer the properties which she has alienated by dint of the original Exhibit 3A. After executing such instrument, she had no limited interest or for that matter no vestige of title left in her in respect of such demised property on the date on which the Hindu Succession Act came into effect. Such limited interest being sine qua non for perfecting her title to absolute ownership by dint of section 14(1) cannot equate the same with her possession in respect of the said property. Records of right, primarily documents of possession, do not give rise to any title. Rather, such documents follows title. Consequently, the record of rights cannot endow the said Saraswati.
Exhibit 3A. Where is Exhibit 3A in the judgment mentioned in the trial court?
Lordship, that
Up till Exhibit 3.
that is that deed, 1940 deed. Lordship,
1940 deed.
have an exhibit. Huh? Yes. My lord, this is good.
Oh, subsequently, it has been marked as Exhibit 3A.
Lordship.
Earlier, it was X for identification.
This matter will continue.
Do you intend to continue or?
Lordship, I need these documents. Lordship, I have them.
My lord,
They have it. Lordship, let them serve us.
my lord, kindly please not this week, my lord, next week.
You are interested in seeking adjournment, nothing more than that.
My lord,
So let that matter go out of the list,
no, my lord.
because all the learned councils are waiting for their matters. Let this matter go out of the list. If you intend so, that can be passed. Learned counsel, you are the advocate on record on behalf of the respondents. You have the documents, certified copy of these documents.
My lord, my senior is
So your senior is the advocate on record.
no, my lord, I am the advocate on record, but by some documents in the
You are not aware whether these documents are with you or not. What to be done?
Because Lordship, this document was in our favor. It shows that Saraswati transferred the property in favor of our predecessor in interest. Now, the learned appellate court has held that from this document itself, it is apparent that Saraswati has transferred other properties also, and holding that one of them was this Jutaku. I have not implemented him. That is why my appeal was dismissed.
Now, what is the remedy?
Then Lordship kindly grant us leave for a limited period. We will apply for certified copy of.
How much time will it take?
Lordship kindly fixes the date from the department. Lordship, showing your Lordship's order, we will be applying within 1 week. If we get Lordship, we will get. And we will also make
1 week will be sufficient.
If your Lordship so directs, the department will give. Then after fortnight, Lordship gives the matter.
Fortnight from 7 days or fortnight from today?
Whatever, Lordship, because we have already started. So, Lordship, once we have started, we want to finish it.
The learned counsel representing the appellants commences her submission, but at the midst of her submission, the learned counsel submits that
the addition of
that she is not in possession with the evidence or the exhibits, and he requires certified copy of both the evidence and exhibit.
Yes.
Evidence of the witnesses, ব্র্যাকেটে দিয়ে দেবেন PWs and DWs, ঠিক আছে, and the exhibits on behalf of the plaintiffs and the defendants, ঠিক আছে. Let the matter appear. আচ্ছা,
documents and the exhibits.
Yes, exhibits also. Evidence, PW, DW, and exhibits.
Yes, yes.
Both on behalf of the plaintiffs and the defendants. Certified copy, ঠিক আছে. In such circumstance, the learned counsel representing the appellants is at liberty to obtain the same. Full stop. As such, let the matter appear on ninth of September. 9th of September. Is there direction required upon the department?
Yes, yes. Otherwise, my lord.
As the paragraph, as the matter is fixed on 9th of September, the department is directed to provide certified copy of the evidence, both oral and documentary, at the earliest, if applied for.
Yes, yes. আপনি apply করে দেবেন, কালকে apply করে দেবেন. Grateful, my lord.
Next, এই নিন ওটা ওর ভেতরেই থাকবে, বুঝেছেন?
Item number 31.
Typed copy of the exhibits number 2 and 3.
Your Lordship, one thing, no index has been prepared, but the documents are there.
স্যার একটা কপি দেবেন পার্টিশন ডিডের
পার্টিশন ডিড আপনার কাছে তো আছে আপনার কম্পাইলেশন
কম্পাইলেশনে পার্টিশন ডিডের বাংলাটা আছে
বাংলাটা
ইংরেজি ইংরেজি।
ইংরেজি নেই ইংরেজি দরকার
তাহলে ঠিক আছে
বাংলাই ছিল তো
তাহলে ঠিক আছে
হ্যাঁ আপনার আপনার কাছে
আপনি কি ট্রান্সলেশন করেছেন
না
আমি একটা কম্পাইলেশন
করেছি কারণ কি আপনার কম্পাইলেশনটা দেখেই তো আমি করলাম
আমার কম্পাইলেশন নয় স্যার
এই কম্পাইলেশন অফ ডকুমেন্টস
এই যে
আগের বারে
final compilation of documents.
ও ঠিক আছে ভালো
I'm handing over the compilation of documents, relevant documents, which is mostly relevant in my case.
Compilation of documents.
Yes, Lordship. The list of documents, the list is prepared. Marat partition deed. The relevant is the deed of sale from Pachkori to Renukarani. Deed of sale from Renukarani Chaudhuri to Gopa Shaha. And rectification deed. Thereafter, the rectification deed was made. Thereafter, the judgment in FMA. Application under Order 6, Rule 17, where they sought for the amendment of the claim. And last consolidated claim. Series of order in connection with appealing remand. That remand was in FMA 558201. Remand order first appeal judgment. And thereafter additional evidence taken by first appeal. These are relevant for my case, to substantiate my case, relevant documents. And my lord, I am handing over the.
Mr. Ghosh, they have provided the partition deed.
Lord, partition deed, Lord, you will also in terms of my lord's direction, Lord, we have also
Partition deed.
typed copy.
Thereafter, Creta.
And Lord, so far her compilations are concerned, Lord, all the documents are there. Huh?
Yes.
Kindly release.
Prayer allowed in spite of being prayed.
The next matter, my lord, I heard, I told my learned friend that respondent number 4 has expired in the meantime.
Mr. Datta, you are in on behalf of the appellant.
I told him that you supply me the details.
You are for the respondent. The necessary particulars be provided.
32 for the timing, 2 weeks, my lord, can you,
Let an order be passed in that one.
32. My lord, he's here, my lord, I told him. I will take it.
Mr. Ghosh, let the order be passed in 32. 32 টা একটু দেখান তো।
32.
32 ঠিক আছে। The learned counsel, the learned senior counsel, representing the appellants, defendants appellants submits that who has expired?
Respondent number 4.
Respondent number 4, namely Prabhakar Das has expired. Full stop. In such circumstance, the appellants are directed.
Respondent. I am for the appellant. You supply the details. Yes.
That is between you. In such circumstance, the appellants are directed to seek, make necessary application in this regard. As regards to particulars, there is no order is being passed.
As per provisions of Order 22 Rule 10A.
I am bound to, yes. I will, my lord, I will provide.
That
I will
Dr. is
provide.
correct.
Only act on one line, my lord, kindly act, my lord. Otherwise, my lord,
He has
my lord, other.
he was bound to provide
Right.
the information that this
And I will, my lord, my lord.
No. Let the matter appear. How much time?
After 2 weeks, man.
When will you provide?
Well, within 2 days, my lord, I will provide.
Within tomorrow.
For 2
Okay,
days, my lord.
within Monday.
Yes.
Within Monday, and so the application
Within that week, my lord.
within that week.
Pattern name.
So substitution.
Yes, yes.
Formal. And my recent Supreme Court judgment 2026, that there would be no abatement.
Acha, do you intend to object?
No, my lord.
So on that day, the matter will be taken up for hearing itself. So when to be fixed? When to
Lordship pleases, man, after 2 weeks, man, as you lordship.
তো 2 weeks পরে দাঁড়ান এটা হচ্ছে 20 তো তাহলে 8 তারিখ দেখুন তো 8 সেপ্টেম্বর দেখুন তো
I have prepared myself to argue.
8 September? No, 8 September.
On top, my lord.
Yes, kindly make it.
How much time will it take? Essay?
This will take, my lord, at least, my lord,
Some time.
1.5 hours will take, my lord, I will take. My lord, this is only, my lord, question of law involved and the facts also involved.
So,
Inconsistent, manner in the plane.
So, the matter can be fixed at 2 p.m.
2 p.m. my lord.
8 at 2 p.m.
8 to 2 p.m.
Okay.
Would you lordship kindly, my
Get.
extremely get it, your lordship. A file going in.
As regards to the other matters are being released for the day. Yes. No.
Because item number 36. Can you maybe fixed on Monday? Tomorrow I'll not be available.
If you are not available, let there be someone to apprise the court. Because in the absence of the other side, it cannot be. Nil. You can start. Actually, list of dates.
I have already handed over the topography, the map of the land.
কি বলে এর সাথে দেখুন তো এনভেলপ আছে ওখানে ওই আছে শীট আছে যেখানে ওই টোপোগ্রাফি আছে মানে ওই জমির ছবি আছে কালার্ড আছে একটা ব্ল্যাক এন্ড হোয়াইট আছে there is one colored also isn't there any paper book? There is the paper book আছে তো পেপার বুকে দেখুন ওইখানটা পেপার বুক নেই এটা
সবই আছে 17-22
চলবে তো বটে
এরকম হয় চলতে পারে না বুঝেছেন তো দিনের পর দিন
এখানে ছিল এই জায়গাটাই ছিল তো লেখা আছে এবার
you can comments
Comments from where? Yes, the last application, I am placing the judgment of the. So it is annexed in the paper book.
अरे परमानेंट एग्जिट फाइल है विशाल फाइल तो 27
বাইক দেখো, বাইক দেওয়া খোলো, খোলো। 7/22, 17/22, এসছে 17/22 খোলো।
সোমবার থেকে শুনুন,
My other side, filed the title suit. Thereafter, in the title suit, we are succeeded. Title suit was dismissed. That that was a suit for declaration. In the title suit, it was declared that right title trust of the suit property was
the declaration was not granted, it was dismissed.
Thereafter, the appeal. Thereafter, they filed the appeal.
The first appellate court had set aside the
Reverse the order.
reverse the order.
Reverse the order, and they said that the ordering portion is page 30.
Yes.
That the appeal be and the same is allowed on contest without cost. The judgment and decree passed by
Yes,
the
yes. Yes.
Cartel in TS number so and so is hereby set aside. It is hereby declared that the plaintiff applicant has absolute right and interest in the constituted suit property. The defendant respondent herein are hereby directed to demolish the construction described in so and so, so and so, so and so. Hand over the vacant position of the constituted property.
The first appellate court has come to the conclusion that Pachkoripal, having derived no right title over the suit dag, could not have alienated any portion of such to Renuka Rani Chaudhary.
Yes. For that reason, I want to place the partition deed. That is the genesis of my case. My partition deed is annexed in my company compilation.
Yes.
It starts from page number.
The first one.
Page number 1. And the relevant part is
আচ্ছা কি বলে ওই যে একটা শুনুন এর সাথে একটা ওই আছে দেখুন তো ওখানে একটা লুজ কাগজ আছে, লুজ বা কোনো কাগজ আছে যেখানে ওই টোপোগ্রাফি মানে মানে হ্যাঁ দেখুন আছে 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 কি বলে একটু গুছিয়ে রাখতে হবে, ঠিকই কথা। এই যে খোঁজাখুঁজি করেন, হ্যাঁ খোঁজাখুঁজি করেন, এতে আপনাদের ইমেজ ভালো হয় নাকি? আপনাদের ইমেজও ভালো হয় না। দেখি না না এটা নয় এটা নয়, নাকি এটা 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 ঠিক আছে এটা। আচ্ছা
kind of come to page 13.
Page 13 of the compilation, yes.
Compilation. Can you give 11 lines after line number 12? ইয়ের ক তপশিল সম্পত্তি যাহা প্রথম পক্ষ 5 কোটি পালের অংশ যাহাতে 16 আনা উক্ত খারার মৌজার খাস দখলি মধ্যসত্ত্ব নিষ্কর 112 মানে here it is specifically written that ক scheduled property was the 5 কোটি পাল was allotted to 5 কোটি পাল and but in the
one thing, was there any
no, my lord.
sketch map
In the
along with the
affidavit,
partition?
Lordship was directed
Okay.
that when the partition deed was prepared, it was there.
There was no
Partition deed does not contain any schedule or schedule content.
schedule is
no
there.
major map.
No map is there. No sketch map.
Yes, no sketch map is there.
So we'll have to interpret from the contents.
The contents.
Yes.
Well, it was specifically written that the court opposition property was allotted to 5 crore. But in the appeal, my lord, can we come to page 30 of my paper?
Yes.
But it was written that it is hereby declared that
Page
the
page
30,
30 of
30 of my paper.
paper book.
Yes.
No, there is only one paper book.
Yes, yes.
But why my paper book? 30 of the
Sorry,
book.
my lord.
When you said my paper book, I went to the page 30 of the compilation. Yes, page 30.
It is hereby declared that the plaintiff appellants have absolute right of interest in the co-schedule suit property. Malan, how can the appeal court say so? Because co-schedule property was allotted to 5 crore pal.
No, that is
co-
co-schedule of paint.
And the
Co-schedule of paint. That there difference. Here co-schedule something, there co-schedule something. Why confusion? Well, can you see paint co-schedule?
It is hereby declared that the plaintiff's appellants have absolute
Paint.
right
co-schedule of the plaintiff is not written.
Right, title and interest in the co-schedule food property.
Yes.
Food property means
Co-schedule
I'm fighting at the floor.
suit property.
co-schedule plaint.
Paint.
What is co-schedule mentioned in the plaint?
I have also annexed the consolidated plaint.
After amendment.
Yes. 125.
125. Page 136.
Yes.
জেলা মেদিনীপুর থানা ঘাটাল পরগনার বর্ডার অন্তর্গত খারাপ পৌরসভার 4 নম্বর ওয়ার্ডের 56 নম্বর হোল্ডিং যুক্ত খারাপ মৌজা সংশোধনী জরিপে 365 নম্বর খতিয়ানে 1085/2969 নম্বর দাগে 0.017 শতমিক জমি মায় তদুপরিস্থ অসম্পূর্ণ দ্বিতল পাকা ইমারতি যার চৌহদ্দি উত্তরে ভোলানাথ কম্পিউটার বিরাজি দক্ষিণে সনাতন সাহা বিরাজি পূর্বে নারায়ণ কম্পিউটার গৃহ এবং কৃষ্ণপদ মল্লিকের বিরাজি পশ্চিমে বাদিগণের বিরাজি মানে can you come to my map?
You have prepared. This is your preparation.
আরে আমার কেস তো আমারই প্রিপারেশন হবে
ঠিক
তারপরে
আছে।
তুমি দেখাবো একে
There must be consensus with the
Yes.
rule of the property.
1085
1085.
শতমিক of land that is Renuka Rani Chaudhary sold to Gopa Saha. That পশ্চাৎ দিকে মাটির দেওয়াল পরবর্তী সাধারণ প্রাচীর বেষ্টিত গৃহাদি মানে kindly schedule kindly compare I am মানে before your lordship comparing the co-schedule property and and my map.
In the partition deed.
This that is not there in allotment of Panchpuri.
Let us go back to the partition deed.
Yes.
Let us come to the schedules of the partition deed.
Yes.
In 150, both of it starts. Panchpuri's allotment, this the number is not equal.
if I
1 minute. Where is the schedule? Come
to page 26,
26.
if that deed also not contains any issue.
Huh?
Schedule is there.
Where is
But
the
it
schedule?
starts at not page 13. That is not running. Oh, it is not 13 of the deed.
Yes, 13.
Can it see the
It's not the schedule.
no, 13 of the deed. Page 13. Not running page is 30. Yes, not 14, and the deed page also 14.
Oh.
It was made.
Lord, your lordship, কত অফ let me finish. কত তফসিল সম্পত্তি যাহা প্রথম পক্ষ 5 কোটি পালের অংশগত. Next, Lord, it starts.
Yes. 1 minute.
These are Lord up to
1 minute. In the
Lord, it continues up to page 23. These are all the properties allotted to 5 kodi in cost schedule. Up to 23 middle.
Yes, thereafter
cost starts
তফসিল সম্পত্তি যাহা দ্বিতীয় পক্ষ 7 কোটি পালের.
Yes, the entire property 7 kodi.
Yes, তফসিল.
May I place the
Yes, now you can.
Yes.
তপশিল সম্পত্তি যাহা প্রথম পক্ষ 5 কোটি পালের অংশ যাতে 16 আনা মুক্ত কারার মৌজার খাস দখল মধ্যস্বত্ব নিষ্কর 112 নম্বর খতিয়ানে সাঁওতা নামক পুষ্করিণী জল মায় পাহাড় ভিক্ষাদি সহ নিজ রকম 18 আনা অংশে 2042 দাগে পুষ্করিণী 56 2 একর 56 শতক 2039 20 শতক 39 দাগে পার 1 একর 338 1 একর 338 3 একর 3 turn page 14 3 একর 394 শতক মধ্যে রকম অর্ধেক চারানা বলে কি আনা বলে এটাকে কি বলে এটাকে কি আনা বলে মানে সামথিং আনা অংশে
5 আনা সোজাটা 4 আর এই দিকেরটা 1. That is 5 anas.
5 আনা অংশে 1 একর 697 1 একর 697 শতক 22 মূল্য 1000 টাকা 17 আনা উক্ত খরার মৌজায় হাস দখলি মধ্যস্বত্ব নিষ্কর 140 140 নম্বর খতিয়ান.
Learned councils, without going into hearing days after days.
Yes.
Can we shorten this matter? By
Filing written
notes of argument?
Yes.
Just not, it is very short matter. I will show you, lordship. Because I am fighting against a fraud. Your lordship will find that this schedule, this plot of land which my learned friend has in the topography has pointed out, it has not been allotted at all to 5 kodi. Subsequently, after filing of the suit, when the plot was transferred to by 5 kodi to third party, they got a rectification deed which is not there in the partition deed at all, and on that basis they are fighting.
But if that be so, then I have to place my case.
Place your case
in its entirety.
now even Lord
is saying that is not correct.
Lord, even now my friend, kindly see Lord their plan.
Only dispute is with
Not
my
dispute.
Learned councils.
Lord, kindly see.
Let us not get agitated.
Yes.
Let us
Lord, kindly see.
solve the dispute.
Yes.
while the
It will not
admitting the
take much
second
time.
lordship, the learned division bench allow us for conciliation of what is the dispute of land, what is the measurement of the dispute of land, 0.08 acre. There is a very short dispute of very short plot of land, but that conciliation was failed. That is why thereafter the second appeal was admitted.
Your Lordship, can you see that? Take the map on his own swing.
The colored one, yes.
Lord, this plot number they are claiming 1085 by 2969.
2969.
But dear
17 decimals.
70 Sotoming, Lord, not decimal, whatever it may. Lord, kindly see the partition deed. Nowhere in Pachkodi's allotment this plot is there. And Lord, it appears further that on the north, plot number 1085.
Yes, on the north 1085.
It belongs to one Camilla, not of the parties.
Yes, Lordship, kindly come.
That is Lord also everywhere.
Amended plan. Amended plan.
Plaint is not your plaint, it is our plaint.
Let us
What are you saying?
not
kindly.
Learned councils.
My lord.
Let us not fight among
No.
1085 belongs to
1085 some Camilla.
Some Camilla.
Yes, at the admitted position.
Yes.
And my lord, this plot 1085 now, my lord, you will see 1085 Bata 2969.
2969.
It is nowhere in the Pachkodi's allotment.
Achha.
Kindly see, my lord, now, Lord, kindly verify now the co-schedule property, but what he has sold to them, their predecessor.
Lord, if that is so, the entire property is 0.54 decimal of land. Okay, I got 34 decimal of land. For that 34 decimal of land, till date I am paying the registration cost, khazna, everything I am paying.
This is immaterial.
Okay. Oh, that is immaterial, but I have to place before the lordship, whatever my stand is. And they got 17 decimal of land. So 34 plus 17
25.
is total 54. How they can get the 24 decimal of land? They eat there, in their deed itself there is a error.
25. You have not seen our deed.
Yes, it is a error. That
Not
is
a-
only 0.8
Miss Sarkar.
decimal of land.
Miss Sarkar, let me be clear.
Yes.
No one will gain by rising the volume.
My lord,
Yes, Lord.
Only there should be submission.
Yes.
That will bring us to the just conclusion.
Yes.
Total 34 decimal.
54 decimal of
No,
land.
not 54.
34 is my portion.
34 plus
17.
17 is equal to 51. 51. 51 decimal.
37, 1090, that is 37, 0.03. Mother, kindly come to the next page of my map.
Achha, yes. The
1090, that
this one.
No, my lord. Lord, that's second.
नहीं
এই
ওই যে আরেকটা পাতা আছে
দেখুন
বলছে
দেখুন তো এনভেলপে আর আছে কিনা একটা পাতা আছে এটা দেখুন
I am giving only one.
Huh?
One page.
Yes, Miss Sarkar, there's only one.
Now
Let the matter get tomorrow. I will hand over the entire.
So when can it be kept?
Lord, any day, yes, real Lord. Lord, tomorrow at the
No, tomorrow it won't be because tomorrow probably there will be a division bench. I'll be a part of division bench.
My lord.
The entire day, probably.
25th. 25th. Yes.
Because I want to have the matter consolidated.
My lord, I may be corrected. Total is
25th
0.054 Shatomic of land. 1090 that contains 0.3037 Shatomic of land. And 1085. 1085 Bata 2969 that contains 0.17 Shatomic of land. Their portion is 0.017 decimal. Because Shatkori from the partition that I can show your lordship that Shatkori's portion is 0.17. They have purchased their plot from Shatkori.
Both of you, not the written notes now. One page or 2 page in bullet form. Can you provide in the coming week?
Yes, ma'am.
I will also go through.
My lord.
Thereafter,
My lord, only thing.
can I-
Only thing, Lord, I am just for your lordship. Your lordship will go through the partition deed.
Yes.
Whether this particular plot which they have marked, it is there in the partition deed. Next, Lord, what happened?
Specifically, the core schedule and core schedule. What is there in core schedule? and
In the
core
constitution, whether this tag is already at all there, your lordship find, and then, Lord, after filing of the suit, in the suit constitution, we have mentioned this. They found that it is not there. Got the summons. 1.5 years waited, didn't appear. In the meantime, got a rectification deed, which is not there in the partition deed. Through their vendor, a new DAG has been introduced by rectification deed. Thereafter, they filed the written statement. It is fact. It is fact.
The part of us that we have made a rectified deed because there was an error in the
You know,
deed.
Lord,
But they have not
in the
made
parent deed, Lord, which is
they have not made any rectification deed.
I need not.
1 minute. So
Lord, why not at the same time? I'm why are we shouting?
Mr. Ghosh.
Lord, I am just telling what.
Context, so
Lord,
the
then your
contention
lordship,
of Mr. Ghosh is that
what is not in
when
the partition?
yes,
Yes.
in the partition deed, you have Mr. Ghosh has been allotted some portion.
Yeah.
Ms. Sarkar has been allotted some portion. So Mr. Ghosh cannot alienate beyond his portion, and Ms. Sarkar cannot alienate beyond her portion. The contention of Mr. Ghosh is that Ms. Sarkar has alienated a portion through the rectification deed, has alienated, as far as I can understand, Ms. Sarkar has alienated a portion of land beyond the portion which has been allotted to Ms. Sarkar through the partition deed.
Yes.
My lord,
This is the main contention.
I will satisfy your lordship that that is a wrong submission.
This.
I will satisfy.
From record, it will appear. I'm not saying.
Record, I will also satisfy.
Take. All right. চলে হবে কবে তাহলে fix করে যাবে কবে এতে হবে না কিছু আই হ্যাভ সিন করেন ঠিক আছে 23-22 কবে 24 না 25 তারিখ আর ওখানে নয় যে সেপ্টেম্বর 25 ও 25 না 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 আগে আমি ভুল দেখছি 25-26 around 20, then 25th.
25th of August.
Yes.
Yes.
My lord, time may be fixed. When the matter dragged.
Anyone after 2.
After
At 3 p.m. Lord, arbitration matter is there before Justice Khan.
So, any other day?
27th at first হবে না তাহলে সেকেন্ড 25 তারিখ 25th ছিল না তো
next week
Lord, then 3rd September Thursday. No division bench is there, I think, Lord. On Friday, your Lord is.
I think it will be better on 7th or 8th because
yes,
there will be sufficient time in the middle, and
yes,
there will be a long weekend on 4th, 5th,
Lord,
and
on 8 September
8th at 2 p.m.
My Lord. Lord, I will give you a short.
So, 9th
Yes,
at 2
Lord,
p.m. 9th at 2 p.m. Wednesday.
Yes.
9th at 2 p.m.
Here.
10th?
Oh, no, 9th.
9th is okay.
9th.
যেটা my lord বলছে মেনে নিতে এটাই ভালো হবে
No. That should not be. The fact is that we want to dispose the matter. That is the 9th of Ms. Sarkar, Learned Counsel, representing the appellants commences a submission, but could not conclude the same. Full stop. let the matter, Parthard,
Yes, no, it is
let the,
Pathar.
let the matter appear
Already
under the
Pathar.
heading Parthard at 2 p.m. on 9th of September. ঠিক আছে? কি বলে এই ফাইলটা না, এই ফাইলটা একটু কালকে পাঠিয়ে দেবেন এই ফাইলটা।
কিছু বানাতে আমি করে দেবো।
যেগুলো হাতে দেবো না সেগুলো সঙ্গে সঙ্গে এনভেলপে ঢুকিয়ে দেবেন, বুঝেছেন? এটাও যদি ফ্রেশ এনভেলপ লাগে ফ্রেশ এনভেলপে ঢুকিয়ে দেবেন। এটা
My lord, get. আপনি একটু একটু করে খুলছেন কেন? এক